actual actual situations where there have been panels, grievance committee, pro standards committee, and what their decisions were, so that we can get a kind of a feel for this. Now, I believe most of you are grievance committee. All right, good afternoon, good. What I want to, if there's anybody here from pro standards, I want to make sure we cover that information also. We're going to cover it anyway, just because it's required in the course. But sometimes what happens is, well, I'm not doing that, I'm doing this. Okay, we got to cover certain things as we go along here, just to comply with the NAR rules and regulations. And if there's any directors here, God bless you. All right. Good. Because as having been director for my association for many moons, and I belong to 5 associations. I don't know, just crazy. Well, I've got 5 offices. I'm the owner broker of MJC Realty. I have an office in Newport Beach, Huntington Beach, Seal Beach. I like the beach. One in Palos Verdes, we're hanging on, and one in San Diego. So I've got plenty of things to do, but those different associations have called on my expertise, and so I've been willing to go ahead and serve on those. I am also a master instructor with the California Association of Realtors anymore. I can't use that moniker anymore. It has connotations, so I should probably change it right now. Let's go ahead and change that. Take that out of there. That way we don't get in any trouble, any more trouble than I'm in. Good. Delete. Instructor for C.A.R. for over 25 years. Let's put that in. That sounds like an awful long time. 25 years. Holy cow. Yep. 25 years plus. Good. Space. All right, so I can get all this correct in here, not get in any more trouble than I'm already in. All right, share. Good. Get this back up here. So that's my contact information. A lot of times what happens is you're sitting in the class, you're doing 1,000 other things. At least I would be if I was in the class. And sometimes you don't get it. We're recording this so you can watch it over and over and over. But understand, this is only good for a couple of months, maybe less than that, if NAR decides they want to make some changey poos. So it'll be available for those of you who couldn't make it today, and then it'll be gone, and you'll have to wait till next year just because they change everything every 20 minutes. So as a C.A.R. instructor for 20 years plus, I get all of the court cases we're losing as realtors, and I tell you about them. 1, 2, having served on grievance committee, pro standards committee, arbitration committee, and as board of directors, I'm going to give you some experiences that I've had, so that if you see these or have these, you'll know where to find the information, and or know that you're not the only one that's coming up with these little tiny things. And also, as a designated instructor, I teach the NAR from the National Association. I teach the NAR Code of Ethics. Now, the National Association of Realtors says you have to have ethics every 3 years. You don't have to have it in between that time, but you have to have it every 3 years. So we took it last year in order to be a member of the association, NAR, C.A.R., and your local association. So I don't know what the story is on that, but anytime you go, we're going to go through the Code of Ethics a little bit. We're not going to go through the whole thing because you already did that last month or 2 months ago, whenever you took it. We are going to look at some things that they are considering in the great state of Michigan. All right, and then as a certified real estate consultant, one of the things I found out when I was doing real estate business back in the 80s or 90s, actually, people would come into your office and say, "Hi, I want to buy real estate." I say, "Okay, I'm going to show you, I'll show you these properties." Good, because my brother's sister's cousin-in-law is going to write up the offer. Then why don't you have your brother's sister's cousin-in-law show you the property? I'm paid on commission. If I don't sell you the property, I don't make any money. The one that changed my whole attitude about this was a gentleman who I dealt with in the past, hadn't sold him anything, but he said to me, "You're not on salary? Whose fault?" So I always let everybody know I work on new word in California, compensation. Can't say commission anymore. That's a bad word. So I work on compensation. And as a certified real estate consultant, I basically gave myself permission to use buyer representation agreements in the 1990s. My office policy since 96 is somebody walks in the office, wants to buy real estate, they sign a BRBC. It wasn't called a BRBC back then. It was just a BR, just a buyer representation agreement. But now it's required by law in the state of California. So when I teach that particular class, we go over how you're going to get paid and how to make sure that the buyers and sellers understand all that. Anyway, let's go on with crafting discipline. So the first thing is, if you are mistakenly charged with violating the Code of Ethics, the Border Association bylaws, or the MLS bylaws, you have the right to exonerate yourself. So we're not trying to put people into a position. This is all stuff I have to do. It's just NAR stuff you got to put out there. So if you are wrongly accused, you have the right to exonerate yourself, and you can do that in public. I cannot say, oh man, I was sitting on a panel, and this idiot. I can't say anything. It's privacy information. But you being accused, if you're exonerated, you can go out and publicly say, I was accused of this, I didn't do it, they said. So just letting you know. But if in fact you are in violation of the Code of Ethics, the Border Association bylaws, or the MLS bylaws, you are going to be pursued at the highest level to make sure that you understand and don't do it again, and or we get rid of you. There's a lot of people out there doing our business that shouldn't be in the business. You know who they are in your particular community. It also, we have to make sure that we observe the rights of the people. So we can't talk about any of this. You're sitting on a panel, or you don't even sit on a panel. You come into the grievance committee, they've got an E1, somebody says, well, what's going on here? And they talk about it, and then they leave because they don't qualify. They're in the same office or blood or marriage. They go back to their office and say, wow, you're not going to believe this one. That's now you have violated the Code of Ethics, the Border Association bylaws, and the MLS bylaws. Not MLS, but the Border Association bylaws. And we still have some boards of realtors here in California, so that's why I include them. It's become essential, and if not enforced, then it's worthless. And so one of the things that happened to me when I was getting into the real estate business, I thought somebody had violated the Code of Ethics. Now, you know what you have to do. You get your real estate license. They teach you 10176, 10177. That's the Department of Real Estate's Code of Ethics. You're a bad agent if you do this. You're a bad agent then you join the National Association of Realtors, California Association of Realtors, and when you have to take ethics training, join the association, and you find out, that these are the things you should do to be a good agent. So I thought somebody had violated the Code of Ethics. I filled out, in that case with D1, I sent it into executive officer. Executive officer called the grievance committee. Grievance committee looked at it and said, no, there's no violation here. They called me up and said, Mr. Carlson, there's no violation. I said, wait a minute. And I explained, and they said, Mr. Carlson, you need to know what the Code of Ethics are. That is not a violation of the Code of Ethics. I was like, when you're 24 years old, you think you know everything. So I said, well, how do I find out more information? They said, you join the grievance committee. I thought, all right, judge, jury, and executioner. I want to get on that grievance committee. We're going to take care of these people. So I got on the grievance committee, and I'm serving on the grievance committee. And so, we got all the training on the board and association bylaws. And then we got onto the MLS bylaws. And then we get to now when I started in the real estate business, there were 23 articles in the Code of Ethics. We now have 17. Are we getting less ethical? No. We had 23 articles. We didn't have standards of practice underneath them. Now we have a standard of practice. Give you an example. Article 1 of the Code of Ethics, January 1st, 2025, basically says you will not lie, cheat, or steal from your clients. I thought that was pretty clear. Apparently, it was so unclear it needed 16 more paragraphs to explain what that means. So you have standard of practice, 1-1, 1-2, 1-3, all the way to 1-16 for Article 1. So anyway, what they've done is they figured out, sometimes your interpretation, remember, this is over the 50 United States. My interpretation here in California might be a little bit different than Missouri. So they want to put it out there. They let everybody know this is what that meant. So if you get into this circumstance with a panel, those standards of practice, and what happens is if enough of those standards of practice come up, enough to, you grievance committee gave it pro standards committee made a recommendation, board of directors said, whoa, we need to, they then send that to the National Association of Realtors. If the National Association of Realtors gets enough violations in that area, they make it a standard of practice. That's where these come from. They just don't pull them out of the air. So, Code of Ethics. We're going to go over Code of Ethics. There are 17 articles in the Code of Ethics. 1 through 9 covers clients and customers. So 1 says you won't lie, cheat, and steal. And it goes on down there and talks about some other things that you studied within the last 3 years. You had to take a 2.5-hour class. I used to come up there and do it live. You had to take a 2.5-hour class in Tulare. Y'all in Tulare, right? Good. Okay, just checking here. And then you give me these looks. So you had to understand that 1 through 9 were duties to your clients and customers. Then the 10 through 14 covers the public. So Article 10 says you will not discriminate based on race, creed, color, sex, national origin, religion, familial status, handicap status, sexual orientation, or gender identity. Those are the 9 protected classes at the federal level. What I'm going to show you is it's a little bit different here in California. Okay. Then the last 3 have to do with duties to other realtors, 15, 16, and 17. 15, you won't say bad things about other realtors. It used to say you will not disparage other realtors, but nobody knew what that meant. So now it says you won't say bad things. 16 says you will not interfere with an exclusive right to sell. If I have a listing on this house over here, you're not going to knock on the door. Hi, listen, I know you're listed with Joel, but he's a bum. Cancel a listing and list with me. 16, or if you have a buyer now, as of January 1st, 2024, actually August 17th, but state of California requires a buyer representation broker compensation agreement. We've had it for 4 months anyway. If you have a buyer representation broker compensation agreement, you're not going to say to that buyer, hey, cancel a buyer representation broker compensation agreement with Joel and work with me. That's a violation of your code of ethics. If you interfere with a listing on a house or you interfere with a buyer representation agreement, that's a violation of your code of ethics. Article 16. In California, that's a violation of law. It's called restraint of trade. You're not allowed to interfere with somebody else's business. So what happens here is I'm sitting on a panel, I get this and I go, whoa, this has nothing to do with us on the code of ethics. This is a violation of law. At that moment in time, you may turn it over to DRE rather than you're going to hear it. Because if the DRE says your license is gone, we don't have to worry about, going through any of the panel, the grievance committee, pro standards committee, or any of those. They're gone. So this is why it's important that you understand these code of ethics, number 1, and let other people know about them so that they don't violate. And I often get this question, well, Joel, this person comes in and blatantly violates the code of ethics. Are you going to go down to the association, fill out a complaint? Probably not. I'm going to call them and I'm going to say, hi, Joel Carlson, professional standards director, whatever I am. What you've done is a violation of article, and I'm not going to just say code of ethics. I'm going to say what article it is. And I'd be happy to send you a copy of it. Did you realize that? I don't know what the figure is, but it's well into 90% of the time, they didn't have a clue. They'd gone through the course and were doing 1,000 other things, and they didn't even know it was a violation. And they recant and they say, I'm sorry, I wouldn't have done that had I known, da-da-da-da-da. Thank you for sending it to me. About 10% of the time, they're idiots. And those are the ones we need to get rid of. So, we're going to pursue that. Then I'm going to make fill out an E1 and get it over to the association president. And the association president will then put them into a situation where it's either grievance committee, pro standards committee, or if it's a violation of law, we don't do law. That's the Department of Real Estate. That's handled by the DRE. So Article 16 says you will not interfere. 17 says you will cooperate with the arbitration committee. 14 says you will cooperate with the Grievance Committee, Pro Standards Committee. Article 17 says you will cooperate with the Arbitration Committee. So basically what I say is Article 17 says you'll cooperate with all three of the standing committees, Grievance Committee, Pro Standards Committee, Arbitration Committee. Even though it's alluded to in Article 14, it is delineated in Article 17. So that means that if you violate the Code of Ethics, the Board Association bylaws, or the MLS bylaws, you're going to go to the Grievance Committee, Pro Standards Committee. If there's a fight over money, then we're going to go to the Arbitration Committee. So I joined the Arbitration Committee. I joined the Grievance Committee because I thought, we need to get rid of these people. So I'm sitting on the Arbitration Committee, and I got called. And we drew straws, and I got the short straw. All right, I get to be on. So we're on the panel, right? Now, it's an odd number other than one has to sit on a panel. So it could be 3, it could be 5, 7. Typically, it's not more than 3. You can't find 3 people that want to look at the complaint, discuss it, and say, yes, it is a violation of the Code of Ethics, Board Association bylaws, or MLS bylaws, and then pass it on. So I was on one of the tribunals. I'm sitting there and I'm saying, all right, judge, jury, and executioner, they're in violation. So it went on. I said, well, where'd it go? Well, it went to the Pro Standards Committee. I said, what's the Pro Standards Committee do? Oh, they hear all the testimony. I said, well, I need to be on that committee. They said, okay, join it. And you go to training. I really suggest you do training at least once a month now, just based on the fact that the manual is turned into a 600-page monstrosity, and they give you lots of information here. But I'm not in favor, personally, of trying to learn all that stuff 2 weeks before my hearing. Okay, I want to do a little at a time so I have an inkling. Is it easier to think of thoughts you've already thought once before? Yes. Okay, somebody asked me, when are we going to take a break? Already? All right. We'll take a break probably about 2 o'clock, another one at 3 o'clock, another one at 4 o'clock, another one at 5 o'clock, another one at 6 o'clock. No, we're done at 5 o'clock. I got things I got to get to. So about each hour, take time to get up, stretch, run around the room. I got to get some more go juice. Every once in a while, I got to get a little go juice. Everybody's drinking juice, so I got my go juice here. So I said, okay, then I need to be on the Professional Standards Committee. So I joined the Professional Standards Committee, and we met once a month. I served on that for 2 years before I sat on a panel. So I thought I had a pretty good idea of what was going on here. So I'm sitting on my first panel. We're listening. They're going back and forth. Now, basically, you can't make the case for them. I've sat on so many panels that have said, if you just ask that one question, complain it. If you just ask it, they'll incriminate themselves. We'll be done with this. No, they don't. So we can't do that. We can ask questions for clarity. So we get to the end. Everybody, okay, fine, you can leave. Respondent, complainant, they both leave. And then we're sitting there and they say, okay, what's the recommendation we're going to make? I recommend we hang them. They said, well, we can't do that, but bylaws of the board association or the Code of Ethics. So we made this recommendation, we sent it off, and I went, wait a minute, how do I become judge, jury, and executioner? I don't even know. Who makes these decisions? I said, oh, the board of directors. I said, well, how do you get on the board of directors? They said, well, you have to run for office. So I went down to the association. I said, hi, I'd like to run for board of directors. They said, well, you haven't had enough time with the association. You don't know what you're doing, basically, is what they told me. Well, you know what the problem with that was? I've been on the Grievance Committee. On the Grievance Committee, you learn about the association bylaws. And the association bylaws said there was no age limit. I was 26 at that time. I joined when I was 24. There was no age limit. However, I felt that if in fact, well, here's what it said. If you can get 400 signatures, you can run for board of directors. I went out and I got 400 signatures. I went up to all the association or all of the companies, and I told them what I wanted to do and run. They all said, fine. And I won. All the other board of directors like, we've been doing this for years. You've been doing it for 2 years and you're already on the board of directors. It was a broker. And so what I found out was you need to know this stuff. You need to read these things. You need to inculcate them into your business practice. So all right, I'm on the board of directors now. So we're sitting here, and our president, Tex Griffith, he calls to order. He says, "Okay, what do we got here?" Well, we got a recommendation from the professional standards. And he says, "Okay, here's the recommendation. All those in favor say aye." I said, "Wait a minute, Mr. Griffith." I said, "How do you become judge, jury, and executioner? I don't even know what happened. I didn't even hear the case. I don't even know." He said, "Mr. Carlson, do you understand the Constitution of the United States of America?" I said, "I hope so." He said, "In that Constitution, it is broken up into three areas: the executive branch, the judicial branch, and the legislative branch. Our association is broken up into three areas: the Grievance Committee, Pro Standards Committee, and Board of Directors, so that you cannot be judge, jury, and executioner." Now, that was a real lesson to me, and I thought, I thought I knew this stuff, and it's kind of interesting. You cannot be judge, jury, and executioner. You are one of the steps along the way. The Grievance Committee looks at the complainant, what they wrote. If it is a violation of the code of ethics, based on what they said, we believe what they said, then we pass it on to the next committee, which is the professional standards. Professional standards listens to the testimony. They put together what's called a finding of facts. They write down when a fact is. They then dismiss the complainant, respondent. They sit down, and the three of them go over the testimony they heard, the evidence that was presented, and they come up with a recommendation. And that recommendation is given to the association board of directors, and they hand out justice. And they can basically do anything. We're going to go into those specific items, but what I want you to understand is this is not judge, jury, and executioner. This is not it goes through steps and processes, just like it does in our Constitution: legislative branch, judicial branch, executive branch. All right, so MLS bylaws. Now, you have to know your MLS bylaws. There are model bylaw rules. You participate in this by paying your dues and signing that you will not violate any of the bylaws. There's regional and reciprocal agreements, and you have to understand, in where I'm in Southern California, there are 5 MLSs. I don't know what your MLS situation is where you are, but their MLS bylaws are a little bit different in other situations. They have model bylaws that they all have to follow. They come from the National Association of Realtors. It goes to the California Association of Realtors, goes to your local association, goes out to the MLS. Okay, so these regional and reciprocal agreements, it's significant in that it talks about in your Article 16 that if in fact you list a piece of property that's out of your reciprocal or regional MLS, that somebody that's going to buy it in that area is not even going to know it's available, because they're not looking in your MLS, which is someplace else. They would be looking in the local one. So you either need to join the local one or you need to refer it to somebody. And this is, this is part of the marketing. The whole idea behind this is you sell the property and earn a compensation, not you just have it sitting around out there. So reciprocal agreements. They give you a whole situation of listing procedures. We have something called clear cooperation. I'll talk a little bit about that as we go through that, because clear cooperation comes from the National Association of Realtors. You have to understand a little history here. In 1960, the National Association of Realtors put together the MLS. Now, we had an informal multiple listing service in the state of California since 1800s. I would come to the coffee shop. I'd say, "Hey, I got these listings." You'd be there. You'd say, "Well, I've got these buyers," and we put it together. We wouldn't make the full commission, but we would at least get the property sold and make some. So 1960, they made them, and they put some rules and regs together. All right, so they put them out. You had to follow these rules and regulations if you were a member of the California Association of Realtors and the National Association of Realtors. Now, California is a little bit different than most of the United States, okay? We have our own ideas on how things are to be. in the 1970s, there was a court case called the Marin County Association of Realtors um, versus Paulson. Paulson was mad at his realtor. He sued the realtor and then found out that everybody who's a member of the MLS is a subagent. So he sued all the agents and they all had to respond back. Well, in California, we said, no, we don't want that anymore. So we do not have subagency in the state of California anymore. Okay, based on that court case, you represent the buyer exclusively, the seller exclusively, or both buyer and seller. In that decision, it also came up with another, I call it a division of church and state. If you remember that history, they divided church and state. You can be a member of the association. You do not have to be a member of the MLS. You can be a member of the MLS, and you do not have to be a member of the association. We have non-realtor MLS participants. So understand how this works. If they are a non-realtor MLS participant, they don't follow the code of ethics. They don't have to. Maybe they do, but they don't have to. They haven't signed anything saying they can be grievance committee, pro-standards committee, arbitration committee situation. So I want to make sure that under the listing procedures, you understand there might be people who are listing properties, putting them on your MLS that are not realtors. This was a court case, happened in the early 70s, I think 72. It was called the Marin County Association of Realtors versus Paulson. All right, so documentation, permission, accuracy of information. In your MLS bylaws, it says you will document. When I started in the real estate business, if I sold a piece of property, I had to take my listing agreement into the escrow company and show it to them as to what I get paid and what I was going to pay the other agents. In those days, I don't know why this was such a big deal in Missouri. I found out, and I'm going to give you some information on that because they do business a little bit differently in other states than they do here in California. And they do business a little bit differently in Northern California than they do in Southern California. And the Mason-Dixon line runs right through Fresno. And I'll talk more about that as we go along here. Same law, same code of ethics, same, but they do business a little bit differently. So you need to be knowledgeable in the area in which you're dealing if you're going to be dealing in those. So the documentation involved, there was certain documentation that you had to have in order to submit it to the multiple listing service. You had to have a listing agreement. In the 80s, that kind of disappeared because it was, everybody had the same agreement. Where the 90s it disappeared, 2000s it disappeared. And then all of a sudden we had this situation that happened in Missouri. And it said, you, being members of the National Association of Realtors, must use a buyer representation broker compensation agreement. So we put that together. We've been using it. That agreement is not new. I started using that agreement in 1990, I think in 96. And I told you a little bit about that when I started the class, because I got tired of people saying, I want to use your services to find property, and then I'm going to have somebody else write it up. I said, I don't get paid unless I write it up. I'm on commission. In those days, it was commission. Now it's compensation. Okay, fine. So my office policy has been since the 1990s, 96 to be exact, that you want to buy from me, you sign a buyer representation broker compensation agreement. If you won't do that, don't let the door hit you on the way out. And I've lost a lot of buyers because they wouldn't sign them. Well, be that as it may, it's now law. So, and I found out, well, let me ask you this. How many of you have ever dealt with a buyer or seller that you wish had never been born? We all have. When did you know there were going to be a problem? In the very beginning. My office policy, you walk in my office, I want to buy real estate. Okay, first half hour is free. After that, you either sign a buyer representation agreement or a fee agreement. Sometimes I do commercial deals where they pay me a fee. So they say, well, okay, I'll sign this buyer representation agreement. Now, what am I doing during the first half hour? I'm deciding if I even want to work with them. You all know there's people out there that said, hey, you know what? You're a pretty good agent. I like you. The last agent I had to sue them. What? I always tell them the kind of expertise you need, I just don't have. But down the street at Ripoff Realty, they can help you out. Okay, so I'm not. I've gotten old and grumpy, and so I always decide if I'm going to work with you or not. I've been using buyer representation agreements for a mucho time now because it is required by law. And the escrow companies are not used to this. I have been asked for a copy of the listing and a copy of the buyer representation agreement. They want to verify what we're being paid. Okay, they're an independent third party. You give them this information, they have to verify it. So be ready for them. I want to see the documentation. I understand listing agreements, we've been using them for, but I'm not really up on the buyer representation agreements, other than you have to have one. But in order to protect ourselves, because they're independent third parties, escrow, we want to see it. And then certain permissions that have to be made, who can see what, and then the accuracy of information. You want to be knowledgeable in the area in which you deal. So I'm talking about code of ethics here. You need to be knowledgeable in the area in which you deal. I'm talking about California law. The law in the state of California says I'm talking to you, must be knowledgeable in the area in which you deal. And I'm not just talking geographic, I'm talking about the forms. We have all sorts of forms that we use. Do you know how many forms we have now? I'm a numbers guy. I counted these damn things. Let me see if I can get a forms up here. We'll go here. This is the zip forms. Now I'm using zip forms standard just because what I want to do is I want to make sure that you're clear where a lot of this stuff comes from. And the biggest form, well, let me look at these two forms here. All right, let me get a new share going. We'll go over here to forms. All right, this is the agency disclosure form. This has been law in the state of California since 1988. Nothing's changed. If they violate this law, we're not hearing about it on the Grievance Committee or Pro Standards Committee. It's going to go to the Department of Real Estate. The entire law is on the second page. It's 2079 of the Civil Code in little tiny print nobody ever reads. You should read this stuff. And I'm going to tell you, I hate reading this stuff. I really do. But I know if I don't, I always get myself in trouble. So now, to make sure that you're knowledgeable in the area in which you deal, and I do these classes for C.A.R. all the time, and in associations, I talk to you about this is required on the sale of all real property in the state of California. It used to be just 1 to 4, now it's everything. You must give them a disclosure. And it's a 3-step process: disclose, elect, and confirm. So if they violate this is civil code. We're not going to hear this. This is going to the DRE. Okay, so sometimes I look at this stuff and I kind of back up and I go, ooh, we need to step away from this. We need to tell the complainant, that the complainant wrote up the D1E1 and say, you need to talk to DRE. Sometimes, it's a buyer seller. They're not used to this. They don't want to get involved. We might have to. In order to get rid of some of these bad apples out there, they're making life interesting and they don't care. I had one guy tell me in a grievance committee down in Newport Beach, you're going to fine me $15,000. I don't care. I made $100,000 commission. What? Well, okay, then that's called scofflaw. They don't care. They made so much money on it. They'll break the laws all the time. Well, then we need somebody else to get involved here, because we have a code of ethics. Number 1, 17 articles in the code of ethics, standards of practice, and we have laws in the state of California. If they violate the code of ethics, most of the code of ethics are laws in the state of California. So we probably got a charge of action to make sure that that's taken care of. So this particular form, this is the agency disclosure form, been around since 1988. We must disclose. It's a 3-step process: disclose, elect, and confirm. You give them the agency disclosure form once you form more than a casual relationship. Then the next step is you check off boxes on page 1. This is a real estate purchase agreement. Okay? We're not talking about this today, but this is part of the process, and making sure that if they say, hi, they violated the code of ethics, and we go, no, they violated law, we can discern between the two. They have to check boxes. Now, the law, if you read it, and this is the entire law is right here, remember? 2079 of the Civil Code, the law says if you do not check off boxes, you're in violation of the Code of Ethics. It even gives you some samples here. You're not supposed to complete these because they're sample only. You go to the first page of the purchase agreement, you check off boxes, and it says you just must check boxes. Doesn't say which boxes, it just says you must disclose your agency relationship. If the agent represents the seller, they check off seller. If the buyer represents the buyer, they check off buyer. If they represent both, then they check off both. Can you have a listing agreement and a buyer representation agreement? Yes, then you check off both. If you don't, I think you're in violation of real estate law. Just a feeling I get here. So whatever your broker tells you to do or whatever your office policy is, I'm fine with it. I'm just telling you, you must give them this form. And it tells you exactly when you're to give it to them. It says right here, the law requires each agent, that's you, with whom you have more than a casual relationship, whatever that is, to give you a copy of this form. That's what it says. You're to give it to them at a specific time. What you're going to have to figure out is what's a casual relationship. Okay. My definition of a casual relationship is if you're showing the buyer property, you form more than a casual relationship. You give them a copy of this. If you go on a listing presentation, you form more than a casual relationship. You give the seller a copy of it. Doesn't obligate them to anything. It's just a disclosure, but it's required by law. Now, sometimes the law gets a little gray in here, and that's when we get the Grievance Committee involved and the Pro Standards Committee involved, because it might be a violation of our Code of Ethics. And then down here, you check off boxes because it says you're to check off boxes, but it doesn't matter which boxes you check off. You just must check boxes. And then the last thing is you sign the contract. This is the real estate purchase contract. You sign it. You sign it on page 17. This is now a 17-page form. Last year it was 15 pages, now it's 17. This is our form. This is the broker section. You sign it. The buyer's agent signs, the seller's agent signs. Here's what's interesting and how I sometimes get on a panel, I get these. You're not a party to the contract. It says it right above your signature. If you are giving advice or telling the buyer and seller what to do, you're in violation of real estate law because you're not a party to this contract, unless you have a JD degree, unless you pass the bar in the state of California, or you have an ownership interest in it. If you have an ownership interest in this property, you can make these decisions. If you're an attorney representing him, you can make these decisions. If not, you're in violation of real estate law. You're going to lose your license and be fined. I'm just telling you. Well, then why am I signing it? You're confirming your agency relationship. So when we talk about agency, we have to make sure I'm sitting on the grievance committee. I get this complaint. It's talking about stuff that has nothing to do with the Code of Ethics, the Border Association bylaws, or the MLS bylaws. It's talking about stuff that's a violation of law. We're not talking about this. That goes to the Department of Real Estate. Now, a lot of times, it's not a violation of law. It's a violation of our Code of Ethics, Border Association bylaws, or MLS bylaws. But the person who is writing it up doesn't know how to explain that. At that moment in time, you on the grievance committee can recuse yourself from being on a panel, and you can help that person write it up. Remember, we're trying to get rid of these bad apples, or at least educate them. I told you, my first education, I call them. If they say, Joel, a violation of Article 16, go take a flying leap at yourself. Okay, now we're gonna work on you a little bit. Just how these kind of things work out. All right. So the only reason you're signing this purchase agreement is you're confirming your agency relationship. You're not a party to the contract. You are a party to the listing. The seller and the broker sign the listing. You are a party to the buyer representation broker compensation agreement. The buyer signs it and the agent or broker signs it. You're not a party to this agreement. As a matter of fact, if you have a question on that, it says right here, paragraph 1 with the offer, buyer and seller referred to as parties, brokers are not parties to this agreement. It says it on the first page, it says it on the last page, and we still don't see it. You need to read the stuff you ask people to sign. You need to read the stuff you sign. I know if you're on these committees, you already got a feel for this. I'm preaching to the choir, but I need you to understand this is getting to be serious. And we're not going to push people out of our association or fine them. We're going to report it to the Department of Real Estate. All right. So go on back here to our let's see. All right. So MLS bylaws, rules for participation. Let's see, we finished this up. Good. Okay. So 17 articles. Then we got into MLS bylaws, and you got to know what these have they changed? Yes. You need to get a copy of your MLS by. Why? Because we now have buyer representation broker compensation agreements required by law in the state of California. We're in California, remember? NAR, they changed them back in August 17th, 2024. We got changey poos here in the state of California. Okay, so now we're looking at these different procedures and documentation and accuracy of information. Then we finish up with reporting of this information. So reporting the sales information, it's one of those things. This is how we get our comparables. All right. Then we come on here to prohibitions and requirements. You are prohibited by the by the MLS bylaws from giving out the information that is copyrighted. If you've served on the grievance committee, you've gone through the bylaws of the MLS, and you know certain things you cannot do. And if you do them, you're in violation of MLS. I call up, I say, did you know that's a violation? They say, go take a flying leap at yourself. Okay, fine. Then we're going to have you before the grievance committee, pro standards committee, because you're in violation of the MLS bylaws. And there's certain requirements that you must have, as well as if you violate the rules or regulations you're going to be fined. And by the way, if in fact you violate the MLS bylaws, you on the Pro Standards Committee can recommend that they be fined, and that not fined, that they be kicked out of the MLS for a week, a month, a year, whatever. If they violate the code of ethics, you could say they have to take a class like this in ethics, and they could be fined. Then that fine could be as much as $15,000. Well, basically, if I'm kicked out of the MLS, I'm out of business. So I'm real careful about that one. And then there are procedures for rules for the hearing. Let me see, you got a question here. So in the disclosure, BC, no, it's not covered. Okay, if we look at the buyer representation broker compensation agreement. Okay, now here's the question. This is the purchase agreement. It starts out with the disclosure regarding agency. This is the buyer representation broker compensation agreement. In the buyer representation broker compensation agreement, it starts out with the agency disclosure form. That's the first step. You must give them this form once you form more than a casual relationship, right down here. Law requires. However, there's no place to confirm it. In other words, you don't confirm it on the buyer representation broker compensation or on the listing agreement. You only confirm it on the purchase agreement. All right, let me make sure I'm clear on this one. You can have all the listings on all the houses you want. You're not going to make a dime. You can have all the buyer representation, all that you want. You're not going to get paid anything. You must have a purchase agreement in order to get paid. The buyer wants to buy, the seller wants to sell. You put them together under an RPA. In the RPA, it says disclose, elect, and confirm. Here, it just says disclose. There's no election. And the reason is, the buyer representation agreement. Could I represent the seller too? Yeah, I just don't know. I say, buyer, we're sitting down here, we're talking. I might represent you also as a buyer and represent the seller because you buy one of my listings. Just make that disclosure. If I have a listing on the listing agreement, it doesn't say anything about a confirmation. Let's go down here to the listing agreement. Residential listing agreement. It doesn't say anything about a compensate or confirmation, it says that if you have a listing on the property, if you find a buyer ready, willing, and able per the terms of listing agreement, you get paid, but you have to have a purchase agreement. All it says is, hi, you represent me, the seller. You might represent the buyer also. You have a listing agreement and you have a buyer representation agreement. So the only one that you get paid on is this one. And that's why when this first came out, I was like, well, what are they talking about? A buyer representation broker? That doesn't get you paid. You have to have this. If you have a buyer wants to buy, if they don't buy anything, you don't get a dime. So this is where they want the 3 steps. First step is you give them the agency disclosure form. Second step is you check off the boxes. Third step is you confirm your agency relationship to represent the buyer exclusively, seller exclusively, or both buyer and seller. And the reason I bring all this up is because this is legal stuff. We don't do legal stuff. We send it away. Sometimes we get a little excited though. We say, oh, I want to hear this case. That's when you give it to your attorney, and your attorney at the association says, that's out of our purview. That's going someplace else. Do not throw that out there because you're promulgating illegal activity. Talking from experience here, okay? So that I just want to make sure that you understand when you're looking at these, that your bylaws, you definitely are part of that. Grievance committee, pro standards committee. Grievance committee says if what Realtor A says is true, it is a violation of the MLS bylaws. If what Realtor A says is true, it's violation of the code of ethics. If what Realtor A says is true, it is a violation of the board or association bylaws. All right. So board association bylaws, they're model bylaws from National Association of Realtors. They must contain these articles. All right, so NAR wrote them up, gave them the C.A.R. C.A.R. includes these, but they have some other things that they put in here. It's more, each state gets to put in their own stuff saying, this is how we do business here. All right, now we got to do a little trip on the Wayback Machine. Those of you who were kids during the 1960s, there was a television show and it featured a Professor Peabody. He had a time machine. He called it the Wayback Machine. So we're going to jump on this is one of the things I had to get clear in my mind when they came up with this thing in Missouri, and I'm in California. So we jump on the Wayback Machine, time machine, we go back to 1620. In 1620, the Mayflower landed and it brought with it English common law. English common law says you cannot represent both buyer and seller. They use a two-party debt instrument called a mortgage, mortgagee, mortgagor, and their community property laws are different than they are here in California. All right, got it. Now we jump back in the time machine. We go back to 1848. The Treaty of Guadalupe Hidalgo, when the United States of America got the Western United States from Mexico. It said in that treaty, we Western United States must use Spanish law. Spanish law says you can represent both buyer and seller. We use a three-party debt instrument called a deed of trust, trustee, trustor, and beneficiary. And our community property laws are significantly different than what they are in Missouri. So I had to get that in my head when they said, you must do this, because in California, we've always done this. Well, not always. Since 1988, we've disclosed the fact that we could represent both buyer and seller. We could be a dual agent. Most of the United States, 39 states could not represent both buyer and seller. Now there's only 8 of them. 8 states in the United States do not represent both buyer and seller. And I was made aware of this one in the 1980s. I went to the convention back east, National Association of Realtors convention. And this guy came, he said, I'm from New York. He said, your badge says you're from California. He said, in California, you can represent both buyer and seller. In New York, we can't. We can only represent the buyer or the seller. How do you do that? How do you represent both buyer and seller? I said, it's easy. I'm schizophrenic. Well, they all think we're crazy out here anyway. So understand, we get these from the National Association of Realtors, Chicago, English common law, back east, and then we bring them here to California and we make our own adjustments. We adopt and enforce, and those adoptions are done by our state directors, traveling directors, vote on them and adopt them. And then it comes to our association, and our association can have our own bylaws to make sure that they are indicative of our area we work in. Remember, I told you, they do business a little bit differently in Northern California than they do in Southern California. I don't consider Tulare as Northern California. Now, it may be, and I just don't know it, but I have figured out based on when you look at, if we go to the forms, this is our California real estate purchase agreement. We now have, I'm a numbers guy. I look at these numbers, I go, are you kidding me? As a certified forms trainer, if I come up here, these are the number of forms that you could use in the state of California to do real estate. We train as a certified trainer about 50 of these. I looked at these, I said, there's a whole lot more than 50 here, and I counted them. January 2nd, as I sobered up, I counted them. 311 forms that you could use in a real estate transaction in the state of California. And they tell you, don't practice law. What? Now, with that in mind, this is for the California Association of Realtors. This is a library. If you click the drop-down box for the library and you come down here to San Francisco Association of Realtors, they have their own forms they use. These are the forms you use in San Francisco. So based on that, I did a little research, called some people, talked to some people, and here's what I found out. They don't open escrow until 5 days before the close of the deal. I said, well, I don't know. That's fine. You can do it that way. You've got to figure it out. I've been taught a little bit differently. So they do business a little bit differently than we do here in Southern California. Based on that, I don't want you making decisions on law. I want you to stay with your code of ethics, your border association bylaws, or your MLS bylaws. And the enforcement and adoption of those bylaws comes from NAR to CAR, CAR to your local association board of directors. Any changes there? All right. The membership. In order to be a member, you have to be in good standing. In the old days, you could say, oh, I'm mad at this association, or this association has kicked me out. And the other associations didn't communicate with each other. So I could say, I'm mad at Newport Beach. I'm going to go to Huntington Beach, or I'm going to go to Beverly Hills. Now you have to have a letter of good standing. I'm going from this association to this association. You got to have oh no, they're not in good standing. They're bad news. So membership, in order to have that membership, you got to pay your dues on time and be a little proactive. And you have duties and privileges. Now, privileges are, I'm a member of the National Association of Realtors, the California Association of Realtors, my local association. That's a privilege. That's not a right, that's a privilege. And I sign that I will follow the bylaws, the code of ethics, and the MLS bylaws. And I have certain duties to make sure that I explain that kind of stuff to my other members out there. And I let them know. I try to be a good example. All right. So now, advertising. There's no name on the sign. Is that a violation of your code of ethics? Yes, it is. Okay. Solicitation. The property's already listed. They're out knocking doors. Hi, I know you're already listed, but Joel is a bum. Cancel a listing and list with me. Is that a violation of your code of ethics? Yes. So there's certain examples on marketing that automatically will get it. I've had both of these situations come up. I've called the respective brokerages. I've explained to them this is a violation of your code of ethics. They both corrected it. We never had to go to a panel. I've only had a couple of times Once that I remember, where they said, I don't care. Oh, okay, fine. We'll see you in front of the Professional Standards Committee. Now, I had to recuse myself because I can't sit on a panel if I've already made up my mind they're no good. It's one of those things. Another example, there's no signed listing agreement. Now, whoa, wait a minute. Somebody put a sign on the property, put it in the MLS and didn't have a signed listing agreement? Yes. In other states, that's not a violation of law. Remember, this is for the National Association of Realtors we're talking about, all the 50 states. In California, that's a violation of law. You can't do this stuff. So that's why in some of the examples, we're not hearing it. That's going to somebody else. The selling agent, no disclosure of dual agency. Again, 39 of the states when it first started out, you couldn't represent both dual agents. The other 8 or the other states, Western United States, you could, but you had to disclose that as the selling agent. You had to disclose I represent the buyer exclusively, seller exclusively. That became specific in 1988. We could represent both. There was court cases on not doing so, but it became law, 2079 of the Civil Code in 1988, that you must disclose if you're a dual agent. And if you don't, you can have your license suspended or revoked. Well, there's other situations where it might not be totally a violation of law. Somebody said, is it time for a break yet? Yeah, we're getting real close. I'm with you on that. It's not totally a violation of law. It's like right on the edge. And you might still Grievance Committee, Pro Standards Committee. All right, so disciplinary, what could happen? You could have a letter of warning. So they violated the Code of Ethics, Board Association bylaws, and the MLS bylaws. In this particular case, the Code of Ethics, you can put a letter of reprimand in for 3 years. You could put a requirement of ethics training. If you violated any of these, if I'm sitting on the panel, you're going to take a class in Code of Ethics. It's just one of those things. It's just like you get pulled over by a peace officer and they say, license, registration, and proof of insurance. Okay, you don't have any of those, you're already guilty. You need to take the Code of Ethics training because you didn't get it. We have it every 3 years. And in California, we have the Code of Ethics in the state of California for the Department of Real Estate is different than the National Association of Realtors Code of Ethics. The Code of Ethics here in California, Department of Real Estate is 10176, 10177. And I alluded to that earlier. You're a bad agent if you do this. You're a bad agent. We're going to take your license away. We're talking about violations of the Code of Ethics for the National Association of Realtors. So appropriate, reasonable fines, and the fine could be as much as $15,000. I don't know about you, but I don't want to hear about any $15,000 fine. 1, 2, remember the example I gave you? That is being considered at this moment in time at the National Association of Realtors that maybe $15,000 is not enough fine. Because the guy said, I've made a $100,000 commission. I'll pay your $15,000 fine and do it every day. Okay, well, we need a little bigger fine. You could be suspended from the MLS. And this suspension could be a week, a month, a year. All I know is if I'm suspended from the MLS or expelled from the MLS, I'm out of business. So this is why it's incumbent upon you as members of the Grievance Committee, Pro Standards Committee, Arbitration Committee, and Board of Directors, that you're constantly talking about, hi, you need to know this stuff. Hi, we're having a class on this. Hi, I'd like you to join Grievance Committee, Pro Standards Committee, Arbitration Committee. Because every time I joined one of those, we had meetings where we would learn a little bit. They weren't, to sit on a panel. They were just, here's education. We're going to go through articles 1 through 5 this month, next month, 6 through 10. So that we would get a feel for these, so that when we did sit on a panel, we had some knowledge. And I'm going to show you some of the changes that they made. 1, 2, how to stay up with some of this stuff. Because it's getting really interesting out there. The old Chinese curse, may you live in interesting times. We're in them. All right, so I'm gonna go through these after we get back from our break. So let's get up, stretch, run around the room. Now, this class is over at 5 o'clock, whether I want it to be or not. That's the rules and regs, so. And if you do have any questions, feel free to put them into the chat. If you say, I don't want to talk about it online, I'd rather call you or text your email, fine. Here, again, here's my contact information. Feel free to call me, text me, email me. I want to make sure that you get the answers, because again, sometimes the answers that you ask are the answers that we're going to be coming up with at the National Association of Realtors, and that as a trainer, I need to make sure that you get the answer for. All right, so let's go back here. But I do want you to know that this recording is probably only good for about 200 years. I mean, 2 months. And then they'll change something else out here, and then they'll let you know about it. All right, so letter of warning from the association, El Presidente. If it is a letter of reprimand, then it's one of those situations where warning, don't do it again. If you do it again, we're going to hit you with something. Reprimand. You've done this. You knew you did it. We're going to put this in your, and we're going to fine you $250. But if you do it again within the next so many months, then we're going to up it to $1,000 fine. So that's one of those where they know. Okay. Share my screen. Thank you. Okay, I'm not sharing. Huh. It says I'm sharing. All right, let me try a different way here. Let's go to here, new share. All right. Now then, is it there now? Let me see. Okay. Recording is back on. What we're doing is looking at a letter of reprimand. So we got the letter of reprimand. Then we have the letter of warning. A letter of warning, here's what happens. Goes to the grievance committee. Grievance committee sends a pro standard. Pro standard says, look, it's the first time you've ever had a problem. So we're just going to put a letter warning in. You come back 6 months later, you've got the same, you're violating the same code of ethics. Then there's going to be a letter of reprimand. And the letter of reprimand basically says, look, we warned you, you didn't get it. We're going to fine you a little bit more. We can only make you take ethics class one time within that 3-year period of time. I wish we could make you take it every 15 minutes, but nonetheless. So, but we're going to fine you a little bit more. And then if you continue, there's going to be another letter in there. Now, I'm going to give you some information when we get into that portion of it about on a panel looking at what I call the jacket. Well, they call that, when you're a criminal, you have a jacket, and they look in there and see what you've done in the past. You're not allowed to look at that until such time as you made your decision. They look like nice guys. They didn't think they would, they didn't mess up too badly. So we'll just do this. And then you look in their file and you see, wait a minute, you were here 6 months ago. Same thing. Now we're going to give you a letter of reprimand and increase your fine. Requirements for ethics training. To me, that's just a natural. I want to make sure that you understand. Sometimes you just don't get it. And I'm with you. I got to sit through some of these things over and over and over again before it hits me. I teach classes all the time on the RPA, the RLA, the BRBC. Sometimes I get to a point and I read something and I go, wait a minute, that was not there yesterday. Yes, it was. I just didn't see it. And it reminds me of the old adage, when the student is ready, the teacher will appear. So sometimes you just don't get it. So requirement of continuing ethics, that's going to be an automatic. Then let's see here. Appropriate and reasonable fine. Now I don't know what reasonable means, but $15,000 per party. And appropriate. We're going to do some moot court. Actually, in moot court, we would break up into different things. We'd be given a scenario and we'd come back with what we thought was wrong. What we're going to do is actually look at cases and what they did and what the panel said their fine is or what they're supposed to do to get a feel for this. Because a lot of times what happens is, I've never sat on a panel. I've listened to some of the dialogue, but I've never sat on a panel. I don't know. And that's why I wanted to show you where you can get sample panel discussions and then actual. Let's see what this says here. Good, all good. All right. So reasonable appropriate fines and probation. You might be on probation, not to exceed 1 year. This is typically for a violation of the board or association bylaws. They put you on probation. You mess up in that year's period of time, we could put it on ethics and say, okay, in your file, we've given you a warning and a reprimand. Now you're on probation. During that time of probation, you mess up again, same thing, then we're going to enact, real punishment, whatever that is. Well, in other words, the person, the panel put it together and said, hi, here's what we see. We open up their file. Whoa, this is the third time they've been back here in a year. We're going to go with the worst or the toughest thing we can so that they get it. And then if they don't get it, if they're back here again within how much period of time, usually less than a year, then we're going to enact, you're on probation or you're kicked out. You're just kicked out, suspension of membership, because you're just not getting it. Some people just don't get it. And typically when you kick them out of them, they have no membership, they go into something else so that they're not making a problem. And this is, again, 30-day month, not to exceed more than a year. However, suspension of the MLS is the same thing, 30 days. Again, if I'm out at the MLS, I'm basically out of business. Now, in commercial, we have lots of MLSs, and that's why when they said you must use a BRBC from the National Association of Realtors, you can't put it, you must put it in the MLS within one business day. Well, we don't use the same MLSs in commercial. We use Crexi, Bravitas, Bravitas, LoopNet, CoStar, things like that. Those are informational services. They're not MLSs. So there were some situations there where we had to make sure that we could stay within the parameters of what our MLS bylaws say, from NAR to C.A.R. to our local association. Expulsion from membership, again, you're out of here. Expulsion from the MLS, and then privileges, the suspension of all your privileges. Again, you're not going to be able to look at anything that's associated with the MLS, and most MLSs, now some of them, this was news to me, have said, we're not going to adhere to clear cooperation. I thought all MLS, well, no, we have a division of church and state. Remember, you can be a member of the MLS and not a realtor. You can be a realtor and not a member of the MLS. Okay, they don't like that, and they want you to prove that you're not using information. And I understand that from a business standpoint. So we have to make sure that your services and privileges are revoked, that we have the right to do those kinds of things. If you're not a member of the National Association of Realtors, we can't, there's no grievance committee, pro standards committee. We might be able to kick you out of the MLS if you're in violation of the bylaws of the MLS. And then professional strategies. Rules that apply to both. Now, this is kind of interesting. And this is one of those things where I said, wait a minute. These are rules of law. No, they're rules of our Constitution of the United States. You have the right to due process, both in your professional standards. So grievance committee, you're just looking at a piece of paper and saying, if what Realtor 8 wrote is true, it is a violation. Goes to the grievance committee. Goes to pro standards committee. Pro standards committee makes a decision and makes a recommendation. They have to use due process there. And we're going to go over the due process, the typical ones that they work. Then representation by legal counsel. They have the right to an attorney. Well, no, we're not trying to, they have the right to an attorney if there's a hearing. Duty of confidentiality. You cannot talk about this with other people. And then there's qualifications of the tribunal. So the tribunal, make sure you're muted here so we don't hear background noise. Qualification of the tribunal, you have to have taken a class, you have to get some training in order to sit on the tribunal. Could be more, it's just an odd number other than one. It's typically 3, but it could be 5. I've never seen one that's 5. That doesn't mean anything. I'm just telling you. So have you had the training? Do you understand what the procedures are? And this is the other one. They can recuse you, just like they do. If you've ever sat on jury duty, you sat on jury duty. So I'm on jury duty. I'm sitting here and I sit down and they say, okay, Mr. Carlson, thank you for being here. You're excused. What? What don't you like? I want to serve on this jury. No, you're gone. Well, they can do the same thing. If there's 10 people on the professional standards committee, and they say, we don't want 2 of them on there. I had one guy say, I don't want that guy on my professional standards committee panel because I had a fist fight with him at the Christmas party. What? Well, okay. If you're related by blood or marriage or in the same office, I got that, but might be other circumstance, or you had a transaction with them. So you can disqualify the people on the tribunal. So you got 10 of you, 2 you're out here, you got 8 to choose from. And it doesn't, your pamphlet, or excuse me, 600 pages of information on this does not say you must do it alphabetically. You must do it by drawing straws. You must do it by volunteer. It says you make that decision. So you get to decide. And the thing that we don't want to happen is we don't want the same volunteering every time. It just doesn't give other people chances, and you need to have this experience also. All right. So now, enforcement system, Pro Standards Reference Manual. So let's take a look at this reference manual. We'll go on over here, go to a new screen share. We'll come to, well, no, that's not, there it is. All right. So we get out of here and we go to the California Association of Realtors. You always know you're at the California Association of Realtors because there's somebody sitting on a house. I don't know what the significance of the person sitting on the house is, but I know I'm at the California Association of Realtors. Okay. So there is a plethora of information in here on what we're talking about today. But mainly, if you go up here and you say, okay, you can find it here someplace. I just don't know how to find it. I always go to search. So I go to search and I type in professional, or I just type in maybe ethics, code of ethics. So we'll put in code of ethics. All right. So from code of ethics, it says, hi, would you like to go to the National Association of Realtors Code of Ethics? I say, yes, I would. So I click on this. It says, terrific. Oh yeah. Do we have enough usernames and passwords? You need some extras? I got extras. So it says, hi, you're at the California Association of Realtors and you're at the Code of Ethics. And if you come down here and click on the Code of Ethics, it takes you to the National Association. It says, you want to go to the Code of Ethics? Go to where they reside. They reside at the National Association of Realtors. All right. Now, this is part of the training as to where stuff is. Because I'm telling you, there's a bunch of it. So you come here, you're at the National Association of Realtors website, NAR.realtor website. You've got your Code of Ethics here. You can download the Code of Ethics, Standards of Practice. If it's highlighted, guess what? It's had changey poos. You need to read it again. Say, Joel, I've been reading this for 30 years. I know, me too. Remember I told you it started with 23 articles when I was there. When I first started, 23 articles, the Code of Ethics, didn't have any standards of practice. Now we got it broken in 1 through 9, customers, clients and customers. Is there a difference between a client and a customer? Not for your Code of Ethics. In the real world, a customer, well, I asked you this earlier, I think. How many of you have ever dealt with a buyer or seller that you wish had never been born? Okay. Those are customers, one time. A client is somebody I'm going to deal with on every time you want to buy a piece of property, come to me. I have sold myself to you and you want to buy through me. So 1 through 9, customers and clients. The public is 10 through 14. 10 says you will not discriminate. 10, I'm going to show you there's more than that in California. You will present it to Article 12 says you will present a new true picture in your advertising. So if you're advertising on Facebook or X or whoever it is, or your website, you will present a true picture on that. It's amazing to me how many times I go to a website. I don't go to them. My clients will go to a website, they'll find the information and they'll call me up and say, hey, I want to take a look at this property. I go to the website they told me and I look at it. I call up the agent, they say, oh yeah, that was sold years ago. What? Oh, wait a minute, it's still on your website. It says it's available. Yeah, we haven't gotten around to saying, no, what you've done is, you got a something that people call on all the time. You're making money on it, so you just haven't decided yet to put sold on it. That's a violation of your code of ethics. It's also a violation of law here in the state of California. Okay, it's called false advertising. So be very careful about that. Make sure that you have your updated websites. And now with the ADA, Americans with Disabilities Act, they have to be able to read it and say, well, it's all in written language. If they can't see, they have to be able to hear it. So you might want to talk to your webmaster and say, hi, we need to comply with ADA. Again, it's not going to be a code of ethics thing. It's going to be a legal thing. And if you violate the Americans with Disabilities Act, here's who knocks on the door. FBI, Agent Scully, Mulder, I don't know. I don't want to hear the knock because that's a violation of federal law. 14 says you'll cooperate with the 3 standing committees, and then the duties to other realtors, 15, 16, and 17. 15 says you won't say bad things. 16 says you won't interfere with their exclusive right to sell or exclusive buyer representation agreement. You know, you got a listing or a buy. You won't try to say cancel and list with me. And you say, well, the buyer representation agreement is not a listing. It almost is. It's very close. So if you have an agreement with them, you tell them cancel that and work with me, that's a violation of your code of ethics. As I referred to earlier, that's a violation of law in the state of California. It's called restraint of trade. It's under your civil code. And then 17 says you will cooperate with the 3 standing committees, Grievance Committee, Pro Standards Committee, Arbitration Committee. It gives the most impetus to the Arbitration Committee in Article 17. Now, I want to point out a few things. First of all, the preamble. Under all is the land, upon its wise utilization and widely allocated ownership, depend the survival of growth of our free institutions of our civilization. Now, I've been in 40 different countries in the world, and I know beyond a shadow of a doubt, this is the greatest country. And one of the reasons is your ownership of real property. Do you have to be a citizen of the United States of America in order to own real property? No. Do you have to have a green card? No. Do you have to have a social security number in order to own real property in the United States? No. Do you have to be 18 years of age or older to own real property in the United States? No. That was the Jackie Coogan decision. He was a child star in Hollywood. His parents were stealing all his money. The judge took his money and put it in real estate. You can own it. You just can't sell it. I've been in countries where the only way you own real property is if you're a citizen, or you're in the elite, or you make decisions at the end of an AK-47. So I believe that as a free institutions, you can own real property in the United States. People say, well, blah, 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 blah. Well, wait a minute. They can't take it with them. They can't say, oh, I'm going to take this building and take it over to whatever country. No, it's here. They're going to pay taxes here. Now, Article 1 goes on and it says, duties to your clients and customers, you won't lie, cheat, and steal. And I told you there are 16 paragraphs underneath this that explain what that means, that you won't lie, cheat, or steal. And these are all what are called standards of practice. You need to read through these, and then they give you what are called up here. When you look at the code of ethics, you can go to let me see here, education. And the education will give you certain kinds of training. So you can go down here to ethics training. In the ethics training, let's see here. It talks about training tips when they are. You got to take 2.5 hours, check the code of ethics for its status to see if anything's updated. And then, you can have it on your phone. I used to carry a little card, and on the card it would say da 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 da. Well, I'm looking at that card, I'm going, oh, okay, fine. That's a synopsis of the code of ethics rather than having to read the 15 pages on that. You also, we go back here. Let's see, code of ethics. Let's see, C.A.R. There's also at the California Association of Realtors, there's a summary of these. This is a one-pager, and I like this one page because it's succinct and it talks about 180 days, got to make a complaint. Board of directors are the ones who make the decision. It's where the proverbial buck stops. Grievance committee looks at this, says if what Realtor A wrote is true, it is a violation of the code of ethics, the board association bylaws, or the MLS bylaws. Pro Standards looks at it, listens to the testimony of Realtor A, Realtor B, and says, yes, this is what we recommend. Then they give that recommendation to your board of directors, and your board of directors is where the proverbial buck stops because they are your elected officials. And they can do anything. They can say, good job, bad job, do it again. They can do anything. And you're elected to that position. And there are chair people of these different ones, and I applaud you for being chairs. I've served my time at that position and getting people together, trying to get them educated, reacting to the complainant respondent, and making sure that the forms are all filled out properly. We're going to go over where to find these forms. But this is just C.A.R. Code of Ethics. It's a summary. Rather than having to go through the 600 pages, it just says in this particular instance, this is where they're going to be done. The board of directors is going to look at them. It could be dismissed. And it's also adoption by the board for this. So this is at C.A.R. This is not N.A.R. Then we get down to here, N.A.R. Code of Ethics. There are, if you remember, you're at the California Association of Realtors, you go Code of Ethics. We can click on the Code of Ethics, or we can go right below that to case interpretations. And this is kind of what I want to look at right now, because if you haven't sat on a panel, even if you sat on a dozen panels, there's stuff that comes up that you go, I don't have a clue. What this does is it says, hi, case interpretations, article 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 17. You click on this and it says, okay, here's what happened. It said fidelity to client, case 1-1. And it goes A, B, C, D, and they said they did this, but they didn't do that. And it says during the hearing, they confirmed these items. So now you're doing what's called moot court with the answers already done. So these moot court, they say, this is what we decided based on that, or this is what could be decided. Now, this is moot court that's not enforced, but I like to look at these just based on the fact that there are certain ones that are, those violations come up all the time. 1, 2, 3, 7. Used to be 10, but now it's 12. And there's one other one. I can't think what it is right now. 1, 2, 3, 7, 9. So 1, 2, 3, 7, 9, and 16. The most common. Doesn't mean anything. You hear one that's on 3 and you go, well, that wasn't in there, or on 4, that wasn't in there. But this gives you something for each one and gives you a synopsis. And I like reading these just based on the fact that, okay, now if this comes up, it's easier to think a thought that you've already thought once before. I've already read this and said, oh, maybe these numbers don't have anything to do with us, but it's the concept. This is what happened. This is what the testimony was. This is what should have happened from that aspect. That he was not dealt with honestly by either party in the transaction. Okay, so you brought a complaint, and now you're guilty. That's one of those, that's a real slap in the face. So what I like to do is look at these from that aspect, the Code of Ethics. It also goes back through, let me go back to here, course interpretation. All right, so this is Code of Ethics. arbitration manual, case interpretations, but right above this is something called forms. So now we got forms. All right. So now we get down to forms. There's ethics forms, arbitration forms, mediation form. You say, whoa, wait a minute. We don't have a mediation. I understand. There's a big push right now for mediation. As a certified mediator, I don't know what it is, but better than 50% of the time, I find out what the problem is. I discuss it with the parties involved, the complainant and the respondent, and they're saying the same thing. They just had a miscommunication. So mediation is a big deal. And they now have advocates. So I have somebody that's violated the code of ethics. They go, I don't even know what the code of ethics are. Then you probably need an advocate, somebody who volunteers their time to sit down with you and say, these are the code of ethics. This is the one you're said to have violated. You need to do this and this and this. Not an attorney, not your broker. They're an advocate. Or arbitration, that's money. Typically, when they're fighting over money, they bring attorneys. Okay. You can bring anybody you want, but the only people that, depending on what your policy is, my policy is Realtor A said Realtor B owes some money. Realtor B says, no, I don't. You bring your attorneys. That's great. If I ask Realtor B a question, I want an answer out of Realtor B. I don't want an answer out of their attorney. They are not the complainant. They're not the respondent. They are to whisper, here's the questions to ask. Here's the answers to give, but they're not to address the tribunal. And then you can download all forms that have been changed 2024, and it's a zip file, so you can download those. You can take a look at those. But it does talk about some of the different ones. So we got the E1, this is the complaint. It used to be a D1, now it's an E1, so you can download that. And I want to see personally, I want to see these forms before I have to make a decision on them. I want to see what they look like. And so, okay, E1 complaint, goes to the grievance committee. This is what we're looking for. Yes, no, maybe. Everybody signs. And then if they have any rhetoric they want to put in here. Okay. So I know what the form looks like. And it goes to your association president, and the association president calls the grievance committee. Grievance committee says there's no violation here. 1, there is a violation here. 2, there's no violation here. There's a violation of real estate law. They may send it back, for another type of hearing, if you will, with the DRE. So what I wanted to do personally was I wanted to see some of these forms because, okay, so we got a complaint, good. Then we have notice to respondent. So the complainant fills out E1, E2, notice. Then we got a reply, E3. Then we have grievance committee request for information, E4. Then response of the grievance committee. And it just goes on and on and on. It's like, this is worse than the contracts. All the different forms we can use in C.A.R. to buy and sell real estate. So these are the ones, and most of the time, you're not going to get into all of these. You get into maybe 5 or 6. But you need to know, is there a form for that? And if it comes up, what it looks like. And that's why whenever we have a meeting of the grievance committee, pro standards committee, we always sit down, we go over some of the forms, we go over the code of ethics, we go over some of the forms, we go over pro standards, we go over some of the forms. Even though I'm on the grievance committee, I want to know how the process works so I can better fit in when I'm talking to folks, giving out mine. So this is code of ethics,
Sure.
and we have arbitration forms. Arbitration is about money, fighting over money on any of these
Yes.
kinds. Make sure that you're on mute. We're recording this, so we don't hear the dogs barking and the planes landing in your backyard.
It's so hard for me to know, Mark, to be honest, because
Hold on, make sure you're on mute. Go down and mute yourself here. Thank you. Good job. All right. So this is request for agreement to arbitrate, then request for agreement non-member, right? Then request for arbitration respondent. So you got the complainant, you owe me money. Respondent, no, I don't. And then you have response from the grievance committee, because what they got to do is I got to look at the A1 to say, is this legitimate, or are they just, trying to make problems here? suffice to say that a lot of times the ones who understand this process, they will have frivolous complaints. And so they write this up, it goes to the grievance committee says, no, you already did this last week. We already have something going on here. We're not going to relook at it again. So they dismiss it. And that's a big factor with grievance committee to make sure it's not a frivolous situation, that they're not just trying to make trouble for the committees until finally the committees say, we're tired of this. We quit. No, we need you to volunteer your time, effort, and energy so that this can be taken care of in a timely manner. And then official notice of procedural review. So did we violate any of the due processes? And then seating arrangements, I always, the tribunal's always up here and they sit out there at a table across from each other. It might be different seating arrangements. I have never seen this. And then the format, the agreement, and then if they have an appeal. So this is what's interesting to me, is sitting on the arbitration committee. So the grievance committee said, yep, if what they said is true, we have what we call a procuring cause chart. Now, this procuring cause chart, when I first saw this, I went, oh, this is the decision that the arbitration committee makes on how you're going to get paid. I said, I'm going to make this part of my policy and procedures manual. So I adopted it in the 90s. And let me see if I can get a new share here. All right, so new share. This is the procuring cause chart. This is the table of contents, and it says burden of proof, factors chart. So it just talks about you got to have this burden of proof on who, and then it comes down to the factors chart. Now, they tell you on this factors chart that they are not cumulative. So it's a factors chart, it's a checklist, it's not additive. Some things will have more weight than others. What I wanted to know was, when I first looked at this, there were 25 items. Now there's 23 items. So 23 items here. There's 25 items. 23 talks about, did you have a buyer representation broker compensation agreement? Okay, I'm fighting over, you owe me money. Well, okay, first thing out the door, did you give them an agency disclosure form? Because if you didn't do that, you're in violation of real estate law. That's Civil Code 2079. Okay, I gave them one of those. Okay, the next thing is, did you give them a buyer representation broker compensation agreement? Yeah, I gave them one of those. Okay, then you're going to get paid. When I saw this, I went, holy cow, that's what I need to have. So that's why I instituted it in the 1990s, because if I do the work, I want to get compensated. And 19 talks about, the buyer representation broker compensation agreement, used to be called the BRE, exclusive right to represent. It's just like regular, what do they call those? Listing agreements. So this listing agreement would be, in an instance, you're listing the buyer, but you're not really, you're listing the house. But that listing agreement could be an open listing, exclusive right to sell, or exclusive agency. Well, I want to make sure I'm going to get paid. So I looked at this 23 articles, the new 23 articles, not the 25 I just showed you. And I said, if this is what it takes to get paid, if I'm before the arbitration committee, then I want to put it in my policy and procedures manual. So I want you to know you can do that. You can put it in your policy and procedures manual and make sure that that's available. Okay. I'm not telling you what to do. I'm just telling you that's something that I did based on the fact that I was amazed what was in there. And that if we go to arbitration, we're going to win. If I'm going to go, I want to win. So those are the different, I understood the forms and understood what that procuring cause chart said. So these are some of the forms, and I know, so you got a whole month. Don't go through all the forms in 1 month. Take a few of the forms and then go through some of the code of ethics. So when we're looking at the code of ethics, let's go down to the code of ethics here. So we go down to the code of ethics. In the code of ethics, you might want to do Article 1 through 5. So submit all offers, counter offers objectively as quickly as possible. Real estate law in the state of California, must you present all offers? Yes. So this is, I imagine in some states, they don't have to present all offers based on this. Otherwise, it's law in the state of California. You must present all offers. What they did is they explained to me as objectively and quickly as possible. So I looked at the law, state of California, it doesn't say that. It says you must present all offers. It doesn't say when. It doesn't say objectively. It just says you must present all offers. I was like, okay. So now I must present all offers as quickly and objectively as possible. Law and code of ethics. This is one of those. It's not the big things that will put you out of this business. It's the little things. And that's why I really recommend. And when I, as a chair, when I teach these classes, I do, little bite sizes. How do you eat an elephant? One bite at a time. Don't try and eat the whole thing. Don't try and go through this whole item. And then your board association bylaws, each association has their own bylaws. Make sure they're updated. And then the MLS bylaws, contact your multiple listing service, get a copy of those, most updated, that have been approved by your board of directors. And then use that as one of for the professional standards training. Oh, all right, let's go back here. Get a new share going here. All right. Excuse me. All right. So enforcement system. There's a reference manual, Pro Standards reference manual. It's called Pro Standards Reference Manual and Arbitration. They put them all together. Excuse me. And take a look through this. And then the arbitration. So the arbitration manual is now pushed into there because they figure, and I don't know if this is true or not, but you go to the grievance committee, then you get educated on that. You go to pro standards and you get educated, and then you go, that was how I did it. And I'm not saying that's the only way or that's the right way. It's just how I did it. So I look at that as probably the way it's done mostly. And rules that apply to both. And again, there are powers and limitations. The rules that apply to both are that they have due process. And I'm going to go through a list of the due process. All right, so it's a 3-tier process for disciplinary complaints. Grievance committee, pro standards committee, board of directors. So those of you who are board of directors, you're where the proverbial buck stops. And I applaud you for being there, and I've been in your shoes, and I'm currently a board of director with the Realtors Commercial Alliance. And we're voted in. We're where we can make those decisions. And and this is another one of those, when I teach the class, it's usually a professional standards class, the nuances of it. I let them know, if you're on the board of directors and somebody says, well, I'm not going to do that. Well, if they violated the code of ethics or the association bylaws, you can fine them and you can kick them out. If they say, I'm not going to pay the arbitration, it goes before so the arbitration committee says we fine for the complainant, goes to the board of directors usually will say, we hold same, make it so. Then you get this, the realtor B says, I'm not paying a dime. I always remind realtor B, realtor A said, you owe me money. Realtor B said, no, I don't. Realtor A went to, and they testified, and the arbitration committee said, realtor B, you owe realtor A money. Realtor B says, I'm not paying him. The board of directors, when you join the association, I don't know if you read what you signed. I really hate reading this stuff. I know I hate it, but if I don't, I always get myself in trouble. It says your board of directors have the right to put a judgment against realtor B in the name of realtor A. That's what it says in your standard bylaws. So you got some teeth there, board of directors. You can make sure that this justice that is recommended, that you've approved, is carried out in your association. board of directors. And then we have, okay, so we talked about some forms, disciplinary, a violation of the code of ethics. So grounds for disciplinary complaint, violation of the code of ethics. How many articles in the code of ethics? 17. That's good. Don't get confused. Who knows what it's going to be next year? But we know there's been changes. So as a matter of fact, if it's a violation of the code of ethics, let's take a look at that. Excuse me. So in our code of ethics, if we come up here and it's highlighted in yellow, that means there's been changes. So what you got to do is you got to look through the whole thing to find out where the changes are. Well, the first changes come up in 10. Oh, excuse me, 4. It says that was last year. So this is 2025. Realtors who have a present ownership interest in the property for sale or lease contemplate must disclose in writing the existence of some. Okay. I think that's pretty clear. It's law in the state of California. If you have an ownership interest, you're related by blood or marriage, you must disclose it in writing. It says present ownership interest for sale or lease or contemplated. Now, again, California is a tenant state. So basically, if the lease is longer than a year, you treat it like a sale. You have to give them all the disclosures. They include transactions. They can represent themselves. They can represent. They can represent members of their family. They can represent the firm or brokers thereof. So typically, if there's a violation of the code of ethics, I'm going to show up. If one of my agents is, I'm the broker, one of my agents is accused, I'm going to show up just to find out what's going on. What's cooking here? I can't say anything. I can't do testimony. I can be a witness, but probably just, witness in good standing. But I want to know what's going on here. And sometimes, well, only one time, it was so blatant. I basically said, we throw ourselves in the mercy of the court. I'm firing this guy and I'm reporting him to the Department of Real Estate. They said, fine, show us that and we're gonna get rid of this. We're going to not hear it anymore. We'll send it up as a satisfied with its outcome to the board of directors. Board of directors, you got enough stuff to do. I'm telling you. I don't know. I meet, in Zoom, they meet about every 15 minutes now because they can do a real quick thing, get it voted on and get it out of the way. So that Zoom thing has really made life interesting. Then it says present, representing the entity of which a realtor is a member and immediate family. Okay, so if you have an interest, you must disclose this. So article says in the ownership, you must disclose that. So if you're representing yourselves, representing an immediate family member, anybody by blood or marriage, you must disclose it. If you don't, you're in violation of your code of ethics. California, you're in violation of real estate law. Apparently that wasn't law in some of the different states. We come on down here too. But this is Article 11. Article 11 talks about services for which are customers' standard of practice of competence. And this is one that I always talk about in my classes. You need to be knowledgeable in the area in which you deal. You need to be knowledgeable in the area. So I told you, I know Southern California. If I came up to Tulare County and I tried to sell real estate, I would be incompetent. I don't know what the city's doing. I don't know what the county's doing. I don't know what the rules and regs are in that particular area. In order to sell effectively in that area, I would have to have that specified particular knowledge. I'm just telling you. So in this particular, you have to have competence. It talks about your competence in this. So you say, well, I've been dealing in residential real estate for 20 years. Some guy came to me and said he wanted to buy a commercial building. Well, I understand how that works. I can do that. Really? So you understand estoppels and leases? What kind of, is it measured from the windows? Or is it measured from interior? Is it measured from center post? What square footage is? Are you familiar with how many amps of electricity? Are you familiar with the phase 1, phase 2s, possibly phase 3? If you're not, and you take that on, you're in violation of your code of ethics. You're also in violation of real estate law in the state of California. It says you need to be knowledgeable in the area in which you deal. So be very careful of that one. So they had a few additions here. It says obligation code of ethics in respect to real estate discipline appraisal. Now, appraisers have their own discipline. Are we allowed to do appraisals? Only if you're a licensed appraiser. You're licensed under PAP, Uniform Standards of Professional Appraisal Practice. If you're not, you can't do an appraisal. Appraisers have their own code of ethics, though. And it talks about clients specifically reasonably required to protect the rights and interests in complex transactions. I think they're all complex now. When I look at the fact that, you're doing a real estate transaction, there's over 300 forms you could use. Zip forms, 311 forms now, possible forms you could use in a real estate transaction, be able to explain and understand it, but you can't practice law. And that's why it says, do you know it says in the purchase agreement 3 times? Buyer and seller are advised to consult with a qualified, I don't know what that means, qualified California real estate attorney. California real estate attorney. 3 times it says it in your RPA. It's getting interesting out there. So then it goes on, it says expertise in this where the realtor agent, sub-agent, we don't do sub-agency here in California, I told you. Fiduciary applicant, they updated this. So we've got a little update, our applicable agency duties. So we've had these duties since 1988. Ain't nothing new and exciting in California, but this is new for the other 49 states, or maybe not 49, maybe 39 states. And this is I'm a member of the grievance committee. I got to know this. There's been changes so that when I'm looking at a complainant's E1, I know there's been changes and I need to review these. Here's Article 1611. Shall not engage in anything that is inconsistent with an exclusive right to sell listing or exclusive buyer representation agreement. That's Article 16. Don't interfere with somebody else's business. Apparently that was so unclear. It needed 20 more paragraphs to explain what that means. Interfering with somebody else's business. They come all the way down here, standard practice 1-20. In your training, you should spend an entire day on this, when you're sitting down with your different committees and bring these kinds of things up. Hi, listen, prior to their relationship, you need to be knowledgeable in the area in which you're dealing. If you're dealing with buyer representation agreements, if you're dealing with contractual relationships, you will understand the difference between sellers and landlords. Now, in California, we can't use the term landlord anymore. So this was a C.A.R. or an N.A.R. item. And we have to use housing providers. And that's the new names, words for that. And then in 17, it talks about in the event of a non-contractual dispute, if they owe you money, then you're going to go to the arbitration committee, arbitrate the hearing. And by the way, arbitration committee, that is admissible in a court of law. Okay, so here's what happens. They're fighting over something. It goes to arbitration. Arbiter says, I'm for the complainant, for Realtor A. Arbitration, the tribunal says, board of directors confirm that. Realtor B says, bull, I'm going to go to court and I'm going to sue. They can go to court. They can sue. But what the judge is going to say is, I'm looking at this and it says it was arbitrated. Yes, we did arbitration. What did the arbiter find? The arbiter found for the complainant. Court holds same, case dismissed. It'll be that fast because arbitration was designed to alleviate the holdup in the courts. So you can get this done a little faster. I don't know what it takes you to calendar up there, but it's about 6 months here in Southern California, Orange County, and probably 1 year to get before a judge. And then the judge, first thing the judge says is, have you done mandatory settlement? Mandatory what? Go out there and figure this thing out. Quit wasting my time. I got to go play golf. So you got mandatory settlement. That takes another year. So it's not a fast process. All right. Going back here, we're talking about So we've got. So grounds for disciplinary action, violent rules, MLS, other duties defined, and then violation of California real estate law, felony or crime of moral turpitude. Now, I know there's a definition for moral turpitude, but the best definition I can give you is if you were in the real estate any period of time, they had something called the pyramid. You would each bring 1,000, there were 16 of you, you'd bring $1,000 into the room. Whoever was at the top would get the 16,000 and then the other two would move up. And so that if you were caught doing that in the state of California, you could lose your license, your real estate license. That was moral turpitude. So they have incorporated this in your standards of practice. Whatever your state of, states, 50 different states says is a violation of moral turpitude or a felony, that's violation, you can be kicked out of the association, the MLS, and lose your license, basically. All right, so special situation, current discipline versus arbitration. All right, so now this is one of those, this character has violated the code of ethics, the border association bylaws, or the MLS bylaws. We're in total violation. Okay? And they're fighting over the commission. What's going to happen is the pro standards is going to back off and we're going to go to arbitration. Arbitration is going to go first, concurrent. Arbitration says you owe money. That probably will settle the problem. Then you can do the current discipline, violation of code of ethics, border association bylaws, or MLS bylaws. All right, so now what we're going to do is take another break, take a little break here, get up, stretch, run around. We're going to go through each one of the committees, how much the minimums and kind of education and things like that. So let me see if we're seeing the same thing I'm seeing. No, we're not, are we? Interesting. We should be seeing this. This just says grievance committee. I apologize. All right. Well, let's go here. Let's go to our timer. Let's reset the timer. Do 10 minutos. Ready? How come the time keeps changing? Well, I gotta have fun with something here. All right, let's get this share going here. We're talking about the grievance committee. You say, okay, we've been beating around this bush. The grievance committee, it's a minimum 5 members. Now that's what it says under the NAR to C.A.R. to your local association. It could be more, but it's got to be a minimum of 5. Now, here's what the problem that I have with that minimum. If in fact you are recused of being on that on the grievance committee, one of the tribunal, you can only have 2 of those, and then you're done. So in other words, there's 5 of us minimum. We're all on the grievance committee, or excuse me, yeah, grievance committee. And you have to send a letter to the saying, hi, there's been a complaint against you by Realtor A, Realtor B. Here are the people that are going to be looking at from the grievance committee. Realtor B says, I don't like these 3. There's only 5 of us. If you take away 3, 2 of us cannot make a decision. So you have to be ready for these games. These people understand how this works, and what they'll do is they'll play the game. And they'll say, I don't want this person, and that person. So you want as many people on the grievance committee as you can get. You want as many people on the pro standards committee as you can get. Because what they do is they play this game. It's like when you're sitting on a jury, and you're called in to do jury, and you're called on a panel, and they say, hi, you're dismissed. It's like, for what? I wore a tie, what? It doesn't matter. You're gone. And if too many people are gone, if they get rid of too many, then you don't have enough to hear the hearing, to be jurors, to be on the grievance committee. So that's why I'm always looking for more people. I always say, hi, would you like to get involved with the association a little bit? Yeah, this is one of the things we do. Oh, okay. And then they learn, and now we have 10 or 15. So if this person, complainant or respondent, has any problems with any of the people on there, we at least have 3. They can look at the E1 and say, yes, this is a violation. Then we have duties. It's a violation of the Code of Ethics, Board Association bylaws, or MLS bylaws. And I told you there's some boards of realtors still here in the great state of California. So you're on the grievance committee. You got to know the pro standards, professional, or the Code of Ethics. You've got to know what the bylaws are of your association, and you got to know what your bylaws are in your MLS. And this is how I learned this stuff when the Tex Griffith, he said, "Sir, you don't know your Code of Ethics." And I was embarrassed, I'm young and I don't know nothing. I know that. Well, I did. No, when I was 26, I knew everything. Ask my parents. So what I want to do is I want to make sure that I'm knowledgeable in the area in which I'm dealing. If I'm dealing on the professional standards training, I want to go through it several times. And that's one of the reasons why I said, yes, record this. I'm outlining the things that have changed. Not that much has changed. A few things in the Code of Ethics and a few things in the manual called the training manual for professional standards. But it only has to do with basically the rest of the United States, because we've been giving the agency disclosure form since 1988. That's why I bring this up in the very beginning. We are light years ahead of a lot of the associations in other states as far as making this disclosure, understanding how it works. The panel is formed one from each company, an odd number, not related by blood or marriage. So you can't have, this is one of the things that when I was with one association, there was this broker, very good broker, said, you need to sit on a panel. And so it was full of this one company. Well, only one from that company can sit on the panel. So out of the three, one, and you got to have a broker as one of them, and then blood or marriage to the complainant or respondent, and they can give you challenges. So that's another one of those things where, okay, we got 10 people on the committee. That's great. 5 of them are in the same company. Well, now we're down to 6. And one of them's related by blood or marriage. And, so it whittles it down. That's why you want as many people on there as you can get, so that you don't run into a situation where you have to do inter-board mediation. This is where we've run out of people. We got to go to another association where they don't know anybody. They don't have any recuse. They can't get rid of them. There's no challenges. And then we can get this thing heard. And it's not like, I got to know who you are. It's like, I got to know what the Code of Ethics are, the Board Association bylaws, and the MLS bylaws. I don't care who you are. If you violated these items, you're going to be called before Grievance Committee, Pro Standards Committee. All right, then you can dismiss it. And I don't know. I used to, and I'm a numbers guy, and I love to keep these numbers, but I haven't kept the numbers in a while as to how out of 100, no, let's say out of 5, 2 are dismissed. They're not violations. The person who's writing it up doesn't know the Code of Ethics. Now, I've seen the write-up on the E1. It used to be a D1, now it's an E1. But they said that this violation, or this Code of Ethics, and it wasn't any of those. So it's dismissed based on that. Well, my feeling is, as the chair, I'm going to say, well, wait a minute. If what they wrote is true, even though they got the wrong Code of Ethics or the wrong bylaws, we need to sanction this person. So we need somebody from the grievance committee to recuse themselves from the committee, go and help this person write up the E1. I've done that a couple of times where I've helped them write it up so that they can go ahead, make a better presentation, and this person learns from this situation. If it's dismissed, if it's referred back to the complaint, okay, they say, well, you need to go back and do it again, or forward it to the pro standards. Or the complainant. So, hi, we're going to dismiss this. It has no validity. Hi, you need to have somebody help you write this up, because there's definitely a violation here. You just didn't get the right bylaws or Code of Ethics. Or, whoa, this is really obvious. We're going to the professional standards with this one. Your job's done. Grievance committee, your job's done. You don't have to worry about dismiss, refer back to the complainer, forward to pro standards. And it's confidential. Please do not, I'm telling you, I, I, I would love to just hang out on this and yell about all these boneheads that are in the business, but then I'm called before the grievance committee as a violation of the board or association bylaws, because it says you can't do that. That's not in your, that's in your board or association bylaws. All right. Then a member of the public makes a complaint. Sometimes, they need help. And the procedure is one of you says, hi, we'll go and help them. That can become cumbersome, because what happens is you help them and then they want you to be there to tell them what questions to ask and things like that. So I let them know this is what the violation is. This is how to write it up. If you're really intent on this, make sure that you show up and you get the judgment against this judgment. You get the sanction against this particular person. All right. There's parallel proceedings. So again, grievance committee, arbitration. We're going to let arbitration go first. And you say, well, the grievance committee here's the same thing. Yes, I know. So the grievance committee gets it for the violation of code of ethics. They get it also for the arbitration. We're going to do arbitration first, let that settle out. Because sometimes that takes care of the whole thing. It's all about the money. It's all about the money, right? Nobody's told you. Good, bad, or indifferent. That sometimes solves the whole thing. They're out of the biz. And there could be arbitration parallel. We're going to let the arbitration go first. Civil litigation or DRE complaint. And we let that go first. There's a complaint. This person violated the code of ethics. We want to hear it. No. They're not going to have a license when the DRE takes it away. Let the DRE go first. Or if a litigation. Then this happened a couple of times. The DRE said, well, yeah, we're going to suspend their license for a little while, but that's all. We're not going to revoke it. So the minute they get a license, we want to make sure they're out of here. So we'll bring up the grievance committee again if they try to come back to that association. Then the directors get to review it. The directors, oftentimes, as I've said as a director, the grievance committee has done their job. The professional standards has done their job. We just say, thank you for your hard work. We'll go with your recommendation. Every once in a while, somebody brings up something about, well, wait a minute. This is the 5th time this person's been back in a 5-year period of time. We're opening up their file. Yes, the Pro Standards Committee saw that, but they chose just to go with whatever this is. We think as directors, we need to do a little bit more. All right. Then we come down to timing. It's got to be brought within 180 days, and that's on that little one sheeter. 180 days. If you say, well, I was going to do it and I didn't do it, and it's the 190th day. No, you're past the time period. You could be the complainant. I've had this happen to me one time where it was a D1. The D1 came in, we looked at it and went, whoa, yes, this is a violation. We said, okay, on this date at this time, we're going to give it to the Pro Standards. Pro Standards is going to call you to do evidence, going to call you. They said, oh, that's too much work. We don't want to do that. We withdraw our complaint. We went, whoa, wait a minute. This is a biggie. This is a big violation. We need to take care of this. And so the grievance committee became the complainant. So now the grievance committee cannot hear, can't look at it. So you got 10 people on the grievance committee, 3 of them look at it, they're gone. They can't serve as the committee as a complainant. You pick out 3 and they're accused of looking at anything or doing anything. They cannot have been one of the 3 that was on the grievance committee that says, yes, hand it to the professional standards. They have to be 3 from someplace else. And then they can be the complainant. And what happens is the person who made the complaint that's not going to press it anymore says, here's all the evidence. You go after them. We verify all the evidence and we go after them and have them sanctioned and fined. All right, and then the case study next page. Okay, so Realtor A, who has recently earned the real estate license, has been advertising a listing without disclosing the status as either a realtor or as a real estate licensee. Okay, now, in the state of California, if you are licensed, you must, and you put an advertising out in the newspaper, in a email, and on social media, on the website, you have to disclose the fact that you're a broker, and you can put BKR or agent, AGT. That's California law. Plus, you must put in your DRE license number. Okay, we got that, Joel. How many of you are double O's? Your license starts with 00. That means you got your license in the early 80s or before. I'm 005. It means I got my license 1976. I love it when these guys come up to me and say, yeah, here's my business card. I've been in the real estate business for 200 years. And I look at their card and I say, according to the number on here, you've been in this business 15
I'll
minutes.
help you get connected. Where are we going?
Okay,
let's
hold
see.
on. Make sure you've muted yourselves. We're recording this. Let me see, mute up. All right, let me see. Okay, good. Always make sure you muted yourself. That way we don't hear the planes landing in the backyard of the car, trucks backing up, that kind of thing. Okay, so which article was it? You say, Craig, Joel, I don't know. Well, it's Article 12. Article 12 says you must disclose the fact. It's also a violation of law. So that's why the first thing I bring it up is you're a real estate licensee. Even if you're not a realtor, you still violated something. All right, now then, standing committee, professional standards committee, pro standards, 9 minimum. You say, Joel, we're lucky if we can get 5. I hear you. I'm with you on that. I've been a member of a couple of associations, very tough to get. And what will have to happen is you'll have to go to another association that has a larger standing committee. Remember, this is once the grievance committee says, they take that and they say, fine, the grievance committee has looked at this and said it's a violation of the code of ethics, the board association bylaws, the MLS bylaws. You could be in Alaska and it's the same code of ethics. So these people say the same things. Now, because our laws are a little bit different here in California, we probably want to keep it in California just to make sure that we're complying properly with some of the legal stuff as well as being on the standards committee. You're going to hear the complaint, you make a determination. Okay, so the kicker here is it's already come through the grievance committee. Grievance committee looked at it and said, if what Realtor A says is true, it is a violation. Now it comes to you on the pro standards. It's a violation. Now what you have to do is determine, how much of a violation? So we decide it's this much of a violation. We make a recommendation. You got to take ethics and you're going to be fined $500. We then open up your file. I call it the jacket. You were here 2 months ago. You say, wait. Why wouldn't you know that? You can't be on this, you can't be on the same committees. If you've already heard this, they know it, you're accused of hearing it again. So you look and you go, wait a minute, you were here 6 months ago or last week. I had one, it was about 30 days. You're not getting this. Okay. Now, so as a grievance committee, we hand it to the pro standards. The pro standards committee says, here's what our fine is. We're going to make you take ethics and we're going to fine you $500. If you're back before this committee again within 6 months, we recommend $1,000 fine and take code of ethics, or $5,000 fine. And we tell you, hi, we're going to fine you $500. If you come back in 6 months with the same violation, it's going to be $5,000. Do you think they dance the dance? They stay away from it. Oh, I'm not getting involved in this. I want to stay away from any kind of violation of that if it's going from 500 to 5,000. After 15 days after the complaint, the chair, pro standards, can make a reply. So timing, 15 days after distribution. So they reply to the association president. They can say, well, I think that I didn't do a good job. I want to rehear this. I think the complainant can also say, well, wait a minute, you guys didn't do a good job. And also, if in fact, we haven't even heard it yet, if they're still looking at panelists. So within 190 days, they fill out the E1. They give it to the grievance committee. Grievance committee then gives it to pro standards. Pro standards then says, hi, we are the pro standards. We're the ones going to hear this. Here's a list of people who are qualified. They're not related by blood or marriage. They're not in the same office. They didn't hear anything, you know, if you've ever been before them again, they recuse themselves from being on. Here's the group. The complainant and the respondent can look at this and they can say, we want to challenge this guy. I had a transaction with him and I don't want him in there. You know, I had a run-in with her at the mall. I don't want her in there. So you can have challenges. And this is why I'm really careful with challenges. And my policy is, whether it's right or not, I always say, why? Well, I know if I can if there's 5 of you left and I can get rid of 3 of you, then you can't hear you don't have enough for a pro standards hearing. No, we're not going for that. That's the games that attorneys play so that they eliminate all the people that could do any good on that. All right. Due process may be represented by an attorney or have other non-legal representatives. So this is a biggie. All right. So understand this one. They say, well, I have a right to be represented by an attorney. Yes, you do. But that right says, we're going to ask you a question. If we're the tribunal and we ask you a question as the pro standards committee, as the pro standards, we ask you a question. I want you to answer it. I don't want your attorney to answer it. And I tell the attorneys, do not jump up and say, objection, Your Honor, because this is not a court of law. And if you're too vociferous, I'm going to have you removed. Do I have the right to do that? As the chair of that tribunal, I certainly do. It's in your training manual. Now, I've never had to do that. I did have to tell one attorney, I don't want to hear from you anymore. I want to hear from the complainant, or actually respondent. And if you keep going, I'll have you tossed out. Well, he understood. See, they understand what the rules are in a court. The judge says, you're gone, you're gone. Well, I'm the judge in this particular instance. So I have that ability. They're quiet, but they can whisper and they can say, right, you know, ask this question. See, attorneys they're skilled at this. This is an adversarial situation. You've been accused by Realtor A of violating the Code of Ethics, Border Association bylaws, MLS bylaws. Well, they deal in that kind of thing. And so what they can do is they can say, you need to ask this question and that'll put you in the clear. And I'm going to tell you something. If you're at a professional standards hearing and the complainant or the respondent brings an attorney, I'm going to call a little recess. I'm going to ask the other person who is unrepresented, you need to go and get an attorney. You don't have to, but I'm just telling you, you're coming to a gunfight with a knife. You're going to lose. I've just seen it happen time and time again. Oh, I'm going pro per. I can defend myself, and they lose. So attorneys are fine. The other non-legal representative is typically the broker. So they want to bring in their broker. Remember, broker, you're not the ones named in this. You're culpable based on the fact that you have an independent contractor agreement with them, but you're not. So I don't want to hear from you. You can say, ask this question or answer it this way, but you can't address the panel. Now, if you have different rules, I'm fine with that. I'm just telling you what the NAR rules say. The panel, you got a form, each one of the company, maximum, odd number, usually 3, not related by blood or marriage, and challenges. Now typically there's an alternate. No alternate in the grievance committee because nobody's, however, on the pro standards. So when I first served on pro standards, in those days, we had tape recorders and there was 3, and then there was an alternate. The alternate heard all the testimony, but didn't have anything to do with anything. But my job was to run the tape recorder. So I had to run the tape recorder and then say, stop, flip the tape over, start again, keep going. Well, we got a new tape recorder. Suffice to say, it didn't work. It worked when I tested it, but it didn't work to record. I'm given one job and I can't get it done. So make sure that you test your equipment. Now, they've gotten pretty sophisticated in ability to, record everything without much difficulty. So, but you probably want to have an alternate. So here's what I'm on the tribunal. I'm in the middle of the tribunal and I have a heart attack. Well, it's done. I mean, they're gone and the alternate steps in. Now we got the three. They've been there the whole time. They've heard the whole thing and it keeps on going. So you might have alternates. And I always thought that was great training for the alternates also. Very seldom did they get called, but they got to see how the process works. Selection of the chair the chairperson within 15 days, and then forms that have to be used. So there's three of us. We volunteered, draw straws, however we did it. Who's going to be the chair? Who's going to run this? Who's going to be the spokesperson? I don't know why I typically am, but that's the way it goes, I guess. So you have to pick that, and then you have forms. All right, then it's amended, withdrawn by the complainant, or they don't show up. Okay, we're going to talk about that in a minute. Now, amend. We picked our three. We call the complainant. We call a respondent. They show up. The complainant says, wait. I just found out that Realtor B violated another code of ethics. I want to add it. You can do that after we've decided on this one. So we're going to hear what you've already got and we've approved. It went through the grievance committee. They said yes. Now we're going to be, if it's before we convene as the professional standards, you can amend or withdraw. Okay, but in the middle of it, we're going to keep going forward. And then you can amend it by having another E1 going to grievance committee, going back to the pro standards committee. It'll be a different group that will hear it though. And the complainant can always withdraw. They can always say, you know what, I don't want to mess with this. I don't know what the percentage is on that, but it's rather high in my opinion. When it's an obvious, you complained, they have violated the code of ethics, the board association bylaws or MLS bylaws. We need to get them sanctioned so they don't do it again. I'm too busy. I don't have time. I don't want to do this. And that's when we, as we're already up there as a tribunal, but we may say to the grievance committee, hi, who wants to volunteer to take their place? So the changes to complaint before the hearing, fine. After the hearing starts, it's got to go through a whole new process again. And that's one of those situations where I've had a couple of times where the respondent, the complainant is the one making the complaint, the respondent is the one that's responding. The respondent says something that it guiltifies themselves. They're admitting a different violation. And the three of us go, what? Write it down as a finding of fact. At that moment in time, somebody may want to do something here. Okay, we're going to keep going, but there might be another complaint lodged later on because of their admission of guilt. They don't know the code, the bylaws, or any of those things, so they say things. You go, what? you just admitted guilt in a different thing. We're not even listening to that, but you can't do those kind of things. Then set of rules, there's due process. So continuance fees. I'm going to talk to you about due process and what the steps are in due process. It's delineated by our United States Constitution. Here's the next game, especially done by attorneys or those that are knowledgeable about how things work. They will say, hi, we're going to meet you on this date at this time. We send it out. They've approved everybody. 3 days before they say, we need a continuance. Why? Whatever. Any excuse they want. The first one. No cost. Now, they want to continue again. So we reschedule it for 3 months later. 2 days before they want another continuance. At that moment in time, we can charge them. Now there's you have to have it. You can't just say, well, we're going to charge you $10 million. No, you got to have it already delineated. So no cost the first one, 250 for the second one, 500 for the third one, 5,000 for the fourth one. You know what's going on here? I'm on the tribunal. I'm all ready for this. And then I got to push it off for another 3 or 4 months. I've forgotten the whole thing. I reviewed everything and now I got to go back in and restudy it. So it's a waste of everybody's time. If it's going to waste our time, then we want to be compensated for it. Now, the only problem is in your manual, it says you do not get the continuance fees. You as an individual, you as a person on the professional standards, you as an association, that ain't your money. You have to delineate a what is it called? A charity. So typically associations have their charities they give to. That money has to go to the charity. It can't go to the end of the year party for the directors. Any of these continuation fees. I like your enthusiasm, but we can't do that. No shows. Whoa. Okay, well, let's address this one. So I'm sitting here, we're all sitting here, we're ready to go. The complainant, let's do it the other way. The respondent shows up, the one that's been accused of violating, they show up. The complainant does not. Here's what we do. We wait 10 minutes, then you get on the phone, you call her home, you get on the phone, you call the office, you get on the phone, you call the bar, and we try and find them. Typically what happens is they're stuck in traffic. They forgot, whatever the reason is. But we're waiting there. This is the complainant we're talking about. If we can't find them, then it's like, I made a complaint, but I didn't show up. Okay, then it's dismissed. Now, that's the complainant. The respondent, same thing with the respondent. They don't show up. We call, can't find them. At the end of that period of time, whatever that amount of time is, 30 minutes or whatever you allot as the tribunal, you can go ahead with the hearing. You tried to get a hold of them, document that, called all the different places, left messages. If they don't show up, you can go ahead with the hearing. So here's what Realtor A says. Realtor B, what's your response? Crickets. Thank you. And we're going to go on that. So we let them know you don't show up for whatever reason. We're going to go ahead with this because you're the respondent. You're the one who's being accused of violating. And that's why they love to come up at the last minute and do let's do a hearing. Let's push it out a little ways. That says once the decision is made by the panel, then it's reviewed by legal counsel. And this is another biggie. All right, so we say, here's what we recommend. You give it to your legal counsel at your association. They want to make sure that it follows procedures and that your D&O insurance will cover it. What's D&O? I know what E&O is. What's D&O? Directors and Officers Insurance. Because if your directors and officers insurance say, no, this was you guys messed up, we're not covering nothing. Well, then you can be personally held liable for those decisions. So you want to make sure it goes before and I've had the legal staff say, I wouldn't go forward with this. I've had them say, absolutely, positively not. About 90% of the time they say, fine, go ahead. No, probably better than 95%. They go ahead, no problems. And it can be sent back to rehear or a new panel selected. Now, this is one of those they say, well, you made this decision, you didn't follow due process. I'm your attorney. You give it to me first. I look at it and say, well, due process, I think you should go back and do it again. I ain't going back and do it again. I already did it once. I got my decision. You want to do it again? You get 3 other people. That's why you need a group, because you're not going to get second panel. All right. So now, petition for rehearing, only new evidence. So this is another game they play. They say, okay, fine. We want it reheard, or we need a new hearing, or what do they say? I can't remember what they call it when you're in court and you get a decision, you don't like that, so you appeal it. I'm going to go on appeal. No, we don't have appeals here. What you're going to have to do is come up with something brand new. So we're given the testimony back and forth. It's recorded. Later on, the complainant or the respondent finds out, hey, we didn't have this evidence. It wasn't available to us. We need this heard. So now they can have the panel if the panel doesn't grant a rehearing, then 2 weeks and it's denied. And it goes, they can even cry to the board of directors and have them. But if it could not have been, then we'll probably rehear it. And we pull ourselves out, we take a look at that. And we're not going to rehear the whole thing. Just that one little portion that was missing is what we're going to rehear. All right, each party and then appealed got 20 days to appeal. 10 days after denial, the maximum deposit is $250. So I got some new evidence and I want it reheard, or I think we should be on appeal. So they, good, nope, nothing, $250, that's your deposit. If in fact we find, yes, we're going to rehear it, you give back your money, it's a deposit. If in fact we say, no, we're not going to rehear this, you're just bringing up bull, then you just lost your $250. All right, so let's go back here. So then it says, let me move this out of the way. Finding of facts, disciplinary action recommended sent to all parties. So this is what we recommend. This is still the pro standards. This is what we recommend to send to all parties. All right, now, what if the respondent refuses to honor the director's decision? So now it goes to the directors say, all those in favor say aye. The respondent says, I'm not paying the fine. Remember, this is pro standards, not arbitration. This is pro standards. Well, first of all, if you do not do with what the decision is, you're in violation of your board or association bylaws. So we can kick you out of the board. 1, 2, we can enforce the fine by putting a judgment against you. And so you don't read the stuff that you sign when you join the association. That's part of the standard bylaws that you signed for. So if you don't honor it, they can come after you. There could be a declaratory judgment on this, and this case study continues. So the declaratory judgment says, hey, you're not going to pay, we're going to get a judgment against you. You gave them the right to do that. It's just like an EULA. Remember EULAs? That's an end user licensing agreement. You have Microsoft, you have to click this thing, says I accept. If you don't accept, you can't use the software. Oh, same thing. You accept. When you join the association, you clicked I accept. So now we can come after you and make sure that you do. Realtor A, who had recently earned the real estate license, didn't disclose the fact that they are a realtor. What article is in violation? Okay, well, we said it's Article 12. All right, so now, 2 months later, Realtor A was charged with nearly identical violation. In other words, hi, you're new. We're gonna fine you. We're gonna put a letter of warning. If you do it again within 6 months, then there'll be a fine and we'll make you take code of ethics. So here's what happens. They get the identical same thing, comes up to the grievance committee. Grievance committee doesn't know. They then do it. They then look in the jacket, the file. Oh, you were here 2 months ago. Well, we're going to go with whatever the recommendation is from the previous hearing. So the professional standard said, if they come back within this period of time, we recommend that you increase the fine by this amount and make them take code of ethics 15 times. You can't take it that many times. Okay. 3 months later, the same thing. Hot Rod, you ain't getting it. Now we're going to really throw the book at you. I've never seen a $15,000 fine, but I have seen a $10,000 fine. This person was just not getting it. And they basically said, I'm not going to pay the fine. You're kicked out of the association. Said, good, because I quit. That's what we wanted to hear. Arbitration committee. All right, standing committee 5. And you say, well, we've got 22 on ours, so that's fine. The more, the merrier. And again, I always invite people in. I say, if you never serve on the panel, you'll get the education. This is a voluntary situation. These are all voluntary situations. You, as a director, you're volunteering. So, yeah, but I get to travel. Well, that takes away from your time with your family and your business. So there's a cost involved. Duty to establish rules of the hearing. Presentation of evidence, witness, cross-examination. This is like a court case. I always sit down when I'm the chair of the tribunal on an arbitration. I let them know You're fighting over money. This is like a court hearing. These people are serious and they always, well, I can't say they always, they should always bring attorneys because attorneys, this is an adversarial situation. They owe me money. No, I don't. Nobody does this better than attorneys. Good, bad, or indifferent. That's how it is. So panel selection, we use a form. It's called an A1. There's usually 3, not related by blood or marriage. We have challenges. And again, the attorney will try to challenge everybody out of here. No, you can't challenge everybody out. We got to have somebody left, on the committee. So I always have why. It's got to be a good reason. They have not read the entire manual. This is the arbitration manual. It's about that thick. They haven't read it. So if I tell them, no, you can't do that, they don't say, well, yes, I can. I read it. It's on page 316, paragraph 7. Oh, well, that didn't work. I want to know why. I don't have a reason. We just don't want. Okay, now I know it's cooking. You're just trying to get out of this thing. Representation, attorney or not, that's fine. Tape recording or a court reporter. Now, in this instance, since this is over money, they can have a court reporter. I've only, in the very beginning, in the 80s, we did court reporting, then we did recordings after that. If you want your court reporter, you can have it, but you pay for your own court reporter. I'm the respondent. I'm the one they say, you owe this realtor A money. I'm saying, I don't owe him a dime, but I'm going to hire a court reporter just to make sure it's done properly. And I'm entitled to a copy of the tape if you tape it. No, you're not. We, the association, paid for the tape recording. That's for us. You want a copy of it? You got to pay for it. Now, whatever you want to charge them, there's nothing under the manual that tells what you got to charge them, but I would make sure that it's commensurate with whatever the amount of time, effort, energy it was. All right, so then right of copies, okay. Alternate, we always want to have an alternate in arbitration because it's money. And what does the alternate do? They're in charge of AV. In the old days, it was you were in charge of the tape recorder. If you're still using tape recorders, fine, it makes it easy. But if you have this elaborate system where you have an employee of the association running it, make sure that you get that okayed by your attorney. I got several associations I've dealt with. They have an AV. I was in San Diego, the long table, and they have microphones hanging about every 3 feet to record the conversations. So you want to make sure you're not making, oh, that's stupid. Oh, that's no good. They hear it all. Okay. Don't say anything when they're recording, because if they hear it, that could recuse you from being on that particular panel. And again, I served as alternate many times, and it was always a learning curve. I never had to step in. Nobody ever got sick or in an automobile accident or anything like that, but I learned, and it was a good learning. Now, due process. All right. Though the technical rules of law and of the disciplinary proceeding, either pro standards or arbitration, it's nothing to do with the grievance committee. This is due process in a hearing for violation of code of ethics, border association bylaws, MLS bylaws, or if they're fighting over money. It's very similar, but they must receive due process. It's not exactly the same, and here's due process. These are the items under due process. You have adequate notice. You can't say, oh, there's been a complaint against you, and you have to show up in 2 minutes. No. You gotta give them notice, and you have to give them time to prepare a defense. Now, how much time do they need? I don't know. More than 3 months, they're just dragging it out. That's my opinion. It just happened. It's within 180 days. We still got all the information. By law in the state of California, you have to keep all your records for at least a 3-year period of time. And I'm just telling you what the law is. So you got these records available. You know what happened. So within a 3-month period of time, you should be able to get this all together, prepare a defense. Representation by legal counsel, got it. Challenge, you can say, no, I don't want this person served because of this reason. Necessary continuance for good cause. I got sick, COVID, I was in an automobile accident. Testify on their own behalf. They have the right to go on the witness stand and testify on their own behalf. Now, the reality is this. You got this is either pro standards or arbitration. You got the complainant, you got the respondent. The respondent's the one who wants to testify because who can tell my innocent story better than me? I'm good at lying. I mean, telling my own story. Okay. So they want to testify on their own behalf. You can't stop them. They can always say the reason I did this and this and this was this reason. Here's my backup. I did that and that and that. I didn't violate. I did this and this. They have the right to say. Testify on their own behalf. You can't, if you say no, you can't do that. Guess what? Okay. You can't, you have to give them that ability. Call and cross-examine witnesses. So now I've got this, I'm the complainant. I say, you're violating, and here's my witness. Well, I get to talk to him. No, you don't. I get to ask him questions. No. Yes, you do. That's one of the due processes under law. You have the right to cross-examine as the complainant or the respondent, and notification of, you can't just say, okay, you're kicked out of the association. Why? Well, we made that decision. You have to give me notice of that decision so that I can appeal it. Okay, so this is the things that whenever I submit it, I submit this and it goes before the legal counsel. I'm always worried about this because if this comes back, we're going to have to do it all again. And I'm not going to sit on the panel again. I already made my decision. So if I messed up, I messed up. Evidence and witnesses. They can present evidence. Now, I had a situation on one where I was getting out of the car and the respondent, the person who they were saying, you owe this person money. Actually, no, it was a pro standards. You violated these code of ethics. He was unloading his car and he had like 15 boxes of stuff. And I said, hi, what is all this? He says, this is evidence that I'm a good realtor. I'm going to use this. I said, we're not going through 15 boxes of materials that you're a good agent. Now, that was a violation of due process. What we had to say was, pick out some good stuff. We're not going to listen to all of this. We don't have enough time to go through 15 boxes of you're a good realtor. Pick out some things and let us, the ones that are the best, and we'll, as a committee, as a tribunal, take a look at it. And then witnesses. Make sure the witnesses are not in the room while the testimony is going on. They have to sit out someplace where they can't hear it. I had a situation where I was the alternate. So they said, okay, I'd like to call this other witness. So I went to the door, opened the door, and the witness was listening at the door. Okay, well, they were no longer the witness because they heard testimony. So we said they can't be in there. Just little things like that to keep them separated so they're not hearing, all the stuff that's going on. MLS members only. All right, so now we've got an MLS member. They are not a member of the association. They're not a member of the ward or association. They're not a realtor, but they're MLS only. Could they still violate the MLS bylaws? Yes, we can hear from that. Could they also be in the arbitration? Yes, doesn't have to be realtors. Now, in this particular case, watch this one. Hi, you're taking money from me. You're saying I owe you money. I'm not even a member of this association. I want it heard by what's called AAA, American Judicial Arbitration Services, or JAMS, Judicial Mediation Services. Okay, ours is free. It ain't free, but it's free. That's going to cost. But they have the right to do that because they're not a association. Well, they can say, no, we want JAMS to hear it, or we want American Arbitration Association to hear it. Whoever is qualified in that area. American Arbitration Association is on Shaw in Fresno, so they're pretty close up there. Right to waive, both must agree. So if they want to waive it, they both must agree. We don't need to have all these evidence. We don't need all this stuff. We both waive our right to present evidence. We just want you to take it on what we've given you and give us a decision. If you've got a strong enough case, you can say, hey, waive it. And the other person, yep, we find against the complainant. Or no, we're gonna release this. There's not enough evidence. Be careful of that. No finding of facts is submitted. Now, this is arbitration on the professional standards. Every time somebody says something, a fact, I write it down. Then when we said as a tribunal, they're all gone. We said as a tribunal, we go, did you get this? Yeah, I got that in it. And we make our decision as to what we recommend based on our finding of facts. There's no finding of facts on arbitration. Arbitration, we could all be sitting there daydreaming, and when it's all done, say, okay, we find for the complainant or respondent, or we're going to split it, or however. How'd you get to that? We don't have to tell you. Just saying, that's what the training manual says. And it's confidential. You can't go out and say, wow, I just heard this one, and we gave that guy $5,000. No, it's confidential. If you say it, if you say anything and if you are convicted, you're kicked out of the association or fined. You're in violation of code of ethics and the board or association bylaws. And it's binding. Anytime there's an arbitration, the reason when you signed the association, you said, I'll do arbitration through the association. You go to court, you say, I think this is bull. I'm going to the court. I'm going to sue everybody. Go to court? No. Our judge is going to say, was this arbitrated? Yes, it was. What did the arbiter find? Arbiter found for the complainant. Court holds same, case dismissed. It'll be that fast. All right, so board of directors. Now, what we're going to do, we're going to take another little break here. We're going to do a little board of directors, and then we're going to do some moot. Well, they're really not moot court because moot court is a made-up court. This is going to be actual decisions made by pro standards and your board of directors, or arbitration and your board of directors. Okay, so we'll take about a 5-minute break because we're just about done now. So we'll take about a 5-minute break. We're going to have some fun and games here. Let me go to a new share, go to our timer. Let me go ahead and get a new share here. So we're talking about board of directors. All you folks that volunteered your time for board of directors and went out and got your signatures that's necessary for being on the board of directors. Congratulations. Let me make sure I'm showing the right thing here. Good. So elected by the membership. You're the elected. Now, I've been in situations where nobody was voted in. They just made themselves, they got there, in some of the different countries, they got there by force. You're elected officials. You are the proverbial buck stops. And basically, you in your board, your bylaws, you can do anything. You can say, good job, bad job, go back and do it again. So with that in mind, there are rules and regs, though, that you must follow. You must be elected. You have to have served in a certain capacities. You have to have had certain experiences in order to serve in that capacity. I don't think that I would have been elected or been able to even run with the new bylaws that they have now when I ran for board of directors. It was the East Orange County Association of Realtors back in those days, not Newport Beach. That's who I belonged to. There are procedures that you must follow. And this is another one of those. There's a certain number of directors. If in fact, the person says, complainant respondent loses, respondent says, I get to say who is on your board of directors that gets to listen to this. I don't want this person giving me judgment. I don't want that person. They were in the same office I was 10 years ago, this, that, and they eliminate all the officers who can say, yes, I confirm the recommendation by the either the grievance committee, pro standards committee, or the arbitration committee. They must have meetings on a monthly basis. That's in the bylaws. It's not an automatic review. In other words, hi, here's our recommendation. Directors say, fine. We go with your recommendation. The complainant or the respondent must lodge a review. If they don't, it's done. There's limited scope again. Why do you want us reviewing it? Because we missed this one part. They didn't have this one part. Okay, then we're going to listen to that one part. Here's what has to happen. We're talking about board of directors now. The board of directors, there's 9 of you, let's say. 3 of you have to go and review that one part. And then you come back with your response saying, yes, it needs to be included. I'd like to redo this. And by the way, the board of directors could do anything. I could say, you need to kick these people out of the association and fine them. And they could say, no, we're not going to kick them out of the association. We're going to give them $500. How's that work? I don't know, but you can do basically anything as long as it's in your bylaws. So if you say, hi, the 3 of us say, go back and do it again. We got to go back and do it again, professional standards. If you say, we have looked at this limited scope and we think that this is how it should be changed, it doesn't have to go back and be heard by the board or the Pro Standards Committee. You can make that decision. Now, remember, the 3 of you now cannot vote. You're out of this picture. You cannot vote on, yes, we accept this. Takes a majority. So that's why you got to be careful with these kinds of things. You run out of majorities. Now you got to have somebody else in a different association carry out justice. It's reviewed as a tribunal. That review is a tribunal. So it takes, you got 90, you take 3 out. They do the review. And the documentation considered is only new documentation. Only new docs. That's all we're looking at. The director's action is ultimately whatever the directors say, that's it. Once they've reviewed it and we say this is it, we're not going to review it again. Okay, you can't say, well, let's review it again. It is final. You said we want to review this portion. Board of directors took 3. They reviewed that portion. They said this is how we're going to decide. The respondent can't come back and say, no, I want it reviewed again. They're just wasting time. So enforcement of the award, they can put it, this is an arbitration. They can put a judgment. The board of directors can put a judgment against the complainant, against the respondent. I'm not paying them dime one. Remember the paperwork you signed? You need to read that stuff. And it could be judicial review and confirmation. So your attorney should look at this and say, yeah, you're okay. You're okay with fining them. You're okay with this decision. Or no, as your attorney of your association, no. At that moment in time, we all go on vacation. No, that's not. We're going to vacate the decision on this. Your attorney comes in and says, hi, not a good idea. Then you're probably going to say, we're backing out of this thing. Either you have to have it reheard by somebody else, go to American Arbitration Association or JAMS or something like that. We're not going to hear that. All right, now let's go over here and we're going to go to here again. Oh, that's not it. Is it here? No, here. All right. So we're going to get out of this and we're going to go to, so we went to the National Association of Realtors. You're at the California Association of Realtors. You're at the person sitting in the round, or excuse me, sitting on the house. Okay. This is where this all starts. What I want you to see is where this information is, because it's like one of those things where sometimes I don't sit on a panel for 6 months. Well, I forget all this stuff. I'm trying to sell real estate and take care of the family. So you go to the person sitting on the chair, you go up here to, I always use search and I put in Code of Ethics. Okay. Click on Code of Ethics. It says, fine. You want to go to the code, you click on the Code of Ethics. It takes you to the Code of Ethics here at the California Association of Realtors, 120 years we've been around. You can either go and look at these 17 articles in the Code of Ethics, or you can go to case interpretations, or you can go to arbitration guidelines, or NAR membership marks manual. Just a manual that says, look at these different kinds of things. So what I want you to do is when you're looking at Code of Ethics, you click on the Code of Ethics, it gives you the Code of Ethics. And then if you can download these and you can then look at them and say, they have changed those. So if you say, I've got the old code of ethics. They're changed, highlighted in yellow. That means you might be sitting on a panel that has that change, Article 4 and Article 11 or 6. You got to know there's changes there. If we come back here, let's get out of here. Let's go back to Code of Ethics case interpretations. Now we get down to forms. I want you to know where these are, and I want you to look over these forms. This is like our purchase agreement, our listing agreement forms. You got to know when you're supposed to use the horse and things. So at least if you know where they are, that's your first step. All right, now we're going to go to, let's see what this is, Code of Ethics, good. We've done C. This is just a manual summary. It's a one-pager. And it gives you what I like to do is, they say, well, we're going to learn about these 5,000 pages. No, just tell me a summary first. Give me an idea of what's going on. Okay, now I can look at the 5,000 pages. It's only 600 and some odd pages for your manual. All right, and then Code of Ethics again. And here's our Code of Ethics. Make sure you've gone through these and you understand what they say. I'm telling you, I look at some of these. I called up NAR and I said, what on earth does this mean? Well, what state are you in? Okay, California. Here's what it means. We're different? Yes. California is much different than because you've already had a lot of these things that they don't have in other states. Okay. And we get down to forms. So we took a look at the different forms, download those, take a look at those. And we're not going to do any more breaks. All right, so now we're at the Code of Ethics. One of the things that I found out in the Code of Ethics is there's an area in here under the Code of Ethics. So what I did is I went to the person sitting on the house. I typed in Code of Ethics. It comes up with Code of Ethics. Here's what I want you to do. Make a note. You're going to scroll down until you find Code of Ethics violators. Then you're going to click on this. This is the Code of Ethics violators as of November 2024. If you violate the Code of Ethics, the Border Association bylaws or the MLS bylaws, your picture will be printed and what you did is a violation. You say, Joel, I already know this. Okay, then let's take some of these. Let's look. This listing broker for the sale of a residential property during an open house spoke with some prospective buyers and discovered they had already submitted an offer on a property through a different realtor. The agent asked the prospective buyers if they would be willing to be represented and not signed a buyer representation agreement. When that agent found out, they proceeded on getting the prospective buyers a buyer representation agreement. Prior to that, they had confirmed the evidence. So now they've submitted offers on the part of the buyer. They were in violation of Article 16. So sometimes I read these things, I say, this actually happened. These look like nice people. What on earth did they do to get in this circumstance? And now I can be better at my voluntary job. All right. This was found in violation of 12 Code of Ethics as a result of fined $100 and required to complete ethics. Well, they publicly marketed a property prior to having the effective listing. Online marketing included videos of the property, everything else, and flyers. They didn't have permission to do. Now, that's a violation of your board and association bylaws as well as the MLS bylaws, their cooperation. $100. How long has she been in the business? Because if she'd been in the business longer than 15 minutes, she should have known not to do that. Let's look at some others here. Southland Regional found a violation of 1516, reprimanded for 3 years and required to take Code of Ethics training. That's usually a gimme. You got to take Code of. Here's what happened. They met with the seller of the residential property, was supposed to have been done, provide the seller with counseling on this. And the client during the meeting, the seller set and had the active listing agreement with another broker at the time of the meeting. At the meeting, they said, hey, we're gonna mislead you based on the fact that the claim they use Zillow as marketing properties. But the seller's current listing agent did not. The panel found that they had violated Article 15 because the claim current listing, they didn't use Zillow. So they were in violation. So they got a violation, and I'm surprised they didn't get a fine for that. So they said, we're on Zillow. We re-employ Zillow. We pay Zillow. They didn't do it. So these are actual. This is going to stay on there for at least 3 years. When you violate, you're on here for at least 3 years. Let's see if we can find, well, I want to find one where they violated 6 or 7 of the, here's one, here we go, okay. Anthony, Citrus Valley, 1, 2, 8, 9, 10, 11, 13, fined 15,000 smackers. Evidence from several witnesses presented showing that they had engaged in fraudulent activities related to flipping homes. They took money from their clients, promised to perform repairs that they purchased, but instead used the money for other repairs on entirely different properties. Fairchild then misrepresented the qualifications on these flyers, Articles 1 and 11, failing to protect and promote their clients' efforts. Also 10, because they engaged in a speech involving racial slurs. So this, I'm telling you, this is on the edge of, whoa, that's a violation of real estate law. You lie to your clients, it says, you know, you got to be truthful with your clients. That's under 10176, 10177. So some of these are like, line them up like pillbox. Citrus Valley found in violation of 12 and 9, 3 years, $25,000 fine. I'm thinking 25,000. I can feel the 15,000. I got that one. This is 25,000 or 2,500. What did they do? Listing agent of residential property, panel found they violated 9 because they did not prepare a listing contract, failure to include a beginning date and an ending date. And additionally, they found in Article 12 because they failed to present a true picture in their advertising. I'm just wondering, how does this work? So this is the kind of stuff I want you to review. Before you do a panel, find out what these other people did. They violated all these code of ethics. They got all of these kinds of problems. And what the panel decided. What did they decide? These look like nice people. I don't think they do any of these things. 1, 11, 16, fine $500. They signed, the wife contacted the realtor, requested a cancellation of the listing because her husband didn't want to work with the realtor, but instead they went through a previous listing and would not cancel. Okay, they violated their trust. Oh, now I'm going to just tell you something. Under real estate law in the state of California, you have a contract to list a piece of property or a contract to represent a buyer. Those contracts are based on trust. If they say, I don't trust you, your contract is done. It's void because they're all based on trust. So when they say they don't trust you, you're in deep problems with that. So what I did is I went into Code of Ethics, looked for Code of Ethics violators, and this is not moot court. Moot court is imaginary court. This is real. These people actually violated and were subject to fines and letters of reprimand and letters of been kicked out of the associations. And what I want you to do is be knowledgeable in the area in which you're dealing. Well, let me see here. You're certainly welcome. Let's see. They aren't expensive in most cases. I'm agreeing. I'm with you 100% on that. Sometimes I look at this and say, and that's why I told you, they're thinking about making it higher than $15,000. Just based on the fact that one guy said 15, that's a puny amount. I'm making $100,000. Now that's a pretty big piece of property, making $100,000. But these are the ones that should be protected from people like that. So yeah, it's not, in most cases, I'm really surprised it's not more. Especially now, first-time offenders, okay. But if you look at their file and they violated this several times, how did you get away with $500? I think it should be more than that because you're not getting it. And that's why I tell you, you need to go through and look at these. All right, so we're back here at the great. Any questions? Anybody got any questions, comments, reactions on this? I'm happy to answer any questions you might have. You say, I don't have any questions, Joel, right now, but I will have questions in the future. Perfect. Call me, text me, email me. Don't text me your panels that you're on. You're hearing things say, Joel, this guy did this and this and this. What do you think? Shh, you're in violation of your board or association bylaws. You're not allowed to discuss that. Don't even make it like it's a, let's suppose this happened, because I know if you're sitting on a panel, you're talking about real stuff. But those ones that are published, that's real stuff. I want you to learn from those. If you do have any questions, let me go back here to the great state of information. Again, call me, text me, email me. I'm happy to contact you. But remember, I'm a baby boomer, okay? So I might take more time than you would think to get back to you. It's just because I'm busy. I have things I'm doing. I set aside this particular period of time because I want to thank you for taking the time to gain more knowledge and become a better professional.